item number 1.
None appears dismissed.
Weekly list item number 2.
None appears dismissed.
Item number 3.
No instructions dismissed.
Item number 4.
But in item number 4, I had appeared before the honorable single judge. Subsequently, my lord, she resigned.
It's infructuous.
So that you also may indicate that way.
All right. Counsel for the respondent states that he had appeared before for the respondent before the single judge, but subsequently she has resigned from service. In that view of the matter, writ petition civil 25376 of 2021, in which the impugn order has been passed, should itself be treated as having become infructuous. In that view of the matter, the impugn order does not survive as far as the respondent is concerned. The writ appeal is disposed of in the above terms.
Pardon, my lord, item 2, my lord.
Yes, yes.
My lord, in this PIL, counter urgent file needs some time to file the rejoinder and for upload instruction. My lord.
What's the matter about, sir?
My lord, it is the regarding the building of a illegal construction of a second culvert.
What have they said in the counter?
Counter, they are saying that it is for the benefit of the people, my lord. But actually,
What is it, culvert? What will a culvert do? Nothing.
means to control the level of the water, my lord.
So how can it be harmful?
My lord, due to the during the high tides, my lord, sea water is coming and it is not evenly distributing, my lord. So the culvert is creating problem, my lord. The first culvert only, and then after that they also paying for decision to separate the construct the second culvert, my lord.
All convert for the benefit of the local.
Last audit it was rejected to take upload instruction, my lord. I also have no instructions.
The counter branching.
So this has happened because of the representation of the villagers.
My lord.
The villagers gave a representation wanting a new culvert, and that's how a new culvert has been constructed. So how can you say this is
No, my
against
lord, they are
public interest?
opposing the construction of the second culvert.
Two groups.
I know. I think it's an internecine problem between two groups.
These are all.
When was this counter filed?
Yes.
When
Conference
did June
filed.
2018?
Yes, 2000.
You had 5 years time filed rejoined. You see, the counter affidavit was filed by opposite parties 1 and 2. That is the irrigation subdivision at District Puri. Way back on 20 June 2018, nearly 5 years ago. Paragraph, there was sufficient time for the petitioner to have filed a rejoinder by now. Consequently, the request for further time for rejoinder is hereby refused. Paragraph, a perusal of the counter affidavit reveals that the new culvert was constructed at the request of the Sarpanch of Koran Gram Panchayat by a representation dated 18th May 2017. Stop. It cannot therefore be said that the construction of the second culvert is opposed to public interest. Stop. It appears to be an internecine dispute between two groups of villagers. Consequently, the court is not prepared to entertain the present public interest litigation. It is dismissed as such.
Item number 5.
5, my lord, initially lordships remitted the matter back to the honorable single judge. And thereafter, my lord, honorable remitted the matter back to government. Government rejected, my lord, and we have filed the writ application. And in the meantime, based on Pattapam judgment, my lord, it was. So your lordship remit the matter back, my lord.
Because
Same
that 5 was, and the honorable single judge has relied upon Pathapan Datta and disposed of the matter.
So first day,
Uh,
pleadings are not complete.
Readings are not complete.
So same. So instead of 24th April and all. It's
Yeah,
here,
throughout, my lord, they are covered by the status quo order.
Right.
They are still continuing.
10th July. 1st July.
Status quo, my lord, it was there.
Yes, sir.
Yes. 6 and 7, my lord, is peon and peon, my lord. 6.
6 and 7.
Well,
All right, same.
5, 6, 7.
and 28, my lord, is similar.
28.
28.
All right,
First day disposal, my lord.
all right.
The status quo in all those cases.
Item number 8.
My lord, 7. 7 is DO, Tahsil.
So this is 5, 6, and 28.
No.
7 orders reserved, no?
My lord. My lord, today I have filed the written submission. I have served a copy.
So orders reserved in
Yes.
7.
Orders.
Item number 8.
Item 8, my lord, outsourcing, 8th August.
8th August.
Item number 9.
Item 9, my lord, I am appearing on.
Well, 8 August, well, status quo there, my lord, because some of the
No, my lord, in so far as my outsourcing is concerned, your lordship may not grant status quo because
no, in that case, my
No,
lord,
no.
they are working
Not-
as DO.
no. I am submitting, my lord, in some cases that license has expired in
Oh,
respect of
Then no-
outsourcing agency.
All right, simply 8th August. Right.
Item number 9.
Item
I-
9, my lord, I am appearing on behalf of Mr. P.K. Sahu for respondent, my lord.
That regarding
My
that
lord,
promotion during pendence
promotion.
of first day disposal, your
The
lordship.
first day disposal, my lord, may pass
Similar order.
has passed identical order on 27th of March this year.
Just
my
take that one. Same order.
Item number 10.
Item 10, may I play next week, my lord?
The request to consider the opinion. Next week it will move. List on 12th July.
Item 11.
May I please? Input order is at phase 10, my lord. There, my lord, in an industrial dispute case, my lord, they were terminated from service. That was challenged before the industrial tribunal. And the labor code directed for their reinstatement with 50% back wages.
Again, first day disposal.
No,
sir.
no, my lord, this is not the first disposal. This is the way that is
No,
the
no,
number is
no. Annexure 1 is impugned order.
that is way transferred from tribunal. So perhaps that's
okay.
that's why it is numbered as serial number 2.
I know, but there's no discussion of the pleadings anyway.
Not discussed and well, very interesting. Well, 6% interest has been also granted. Well,
All right, notice returnable. There's no similar matters.
well,
There are no similar matters.
the similar matters in the list today. List. It's the first matter.
Notice returnable.
31, 30.
13th July.
Item number 12.
There shall be stay. So, which are the other connected matters?
That other connected matter, another connected matter, 20. Get number 5.
31,
Item 31
38,
and 36. 31, 36 and 38.
Order.
May pardon, my lord, item 1, I missed the list. Let come next week.
We'll have to wait, sir.
And also 40, ma'am, and 40.
And 58. I'm giving the numbers so that it will be easier. Rather than this.
Item number 12.
Lordship, kindly permitted to withdraw.
Memo taken on record disposed of.
Item number 13.
At 13, your lordship may see the last order, your lordship had directed me to take instruction whether they can be observed. I pray only 1 week, my lord. Your lordship, my lord's order last.
Well, let's say for the opposite party.
I am submitting, I will file an affidavit for your observation.
Yes.
That I am seeking
Yes,
time
yes.
1 week.
Yes, ma'am. No, only I have mentioned for appearance.
3rd May. 3rd May.
Oh, please.
Item number 14.
May I please your lordship, the defect will be removed within 3 days, my lord.
What's the matter about?
Matter is relating to your lordship may kindly see annexure 9/24. Previously, he came to this honorable court and honorable court directed to demolish the house and eviction the encroachers. But it was not complied and contempt petition was filed, and contempt petition in that they inquired again and they said there is no encroachment. First annexure 1 investigated by the Tahsildar and encroachment report was filed and 13 more encroachment case was initiated, man. But in annexure 10 there is no encroacher. For that I pray only to CBI inquiry, my lord.
CBI? First of all, come to the cost title.
Man.
Come to cost title of the case, sir.
Man.
Which of the opposite parties is the encroacher?
My lord, OP number 6 to 10 are encroachers.
Where is 6 to 10? Which is this writ petition? The 8553. Where is 6 to 10?
Item 15.
Item 14, my lord.
Just show that. Okay. I think you've given a different writ petition to us.
8553/23.
See the cost title.
Cost title টা দেখুন তারপর পেজ
My lord, defect, my lord, I remove it within 3 days, my lord, 7 days, my lord.
Or you see list.
for allegation is eviction of unauthorized encroachers not carried out. That is why CBI inquiry has been sought for.
But we don't even know who the encroachers are. He's
That-
not named them.
But for this reason, he has sought for CBI inquiry.
I know. First of all, let him name the encroachers.
Yes, let him file a fresh application. We encroaching enclosing the
I'll-
names.
I'll correct the cause title, my
No,
lord.
no. Have you described the encroachers in the body of the petition?
My lord.
Where is that? Have you said opposite party 6 to 10? Where you will describe the encroachers? The present petition. Where you will describe the encroachers in the body of the petition?
Only 7 days, after 7 days.
No, no, you file a fresh petition. You say that names, the encroachers have not been indicated in the cause title. Even in the body of the petition, there is no description of the encroachers. Permitting the petitioners to file a proper fresh petition in accordance with law, the present petition is disposed of.
Item number 15.
My lord, the limited grievance of the petitioner that seeking direction to the opposite party number 3, that Tahsildar Kujang, to dispose of the encroachment case 39/22 within a stipulated time and simultaneously direct the executive engineer drainage renovate the water channel. And I have implemented the opposite encroachers as opposite part number 6 to 35, my lord. 30 encroachers.
9431.
As it appears, already encroachment cases have been
Initiated.
registered against them. So it will take a logical end.
Where is your prayer clause? You have not mentioned any encroachment case number, you know,
Yes, my lord, I have mentioned.
prayer clause.
No. It's not mentioned.
Yes, sir. My lord, at page 14.
So come to the prayer clause.
At page 14 that,
Sir, come to prayer clause.
my lord. That
Where have you mentioned the case number in the prayer clause?
my case number in the prayer clause is not there, but only simply direct the opposite part number 2 to perform the statutory duty, and for order purposes it is there.
What does that even
But in the content in the body of the petition, it has been mentioned that encroachment case 39/22 is initiated and it is pending. And
Counsel,
in
petitioner
evidence may
states
not
that
direct.
the petitioner will be satisfied if at that stage a direction is given to for early disposal of encroachment case number 39 of 22. Pending
Lordship
before
may
the
see, he has
Tahsildar
stated
Kujang
that
under
30
the
numbers
OPL
of
Act.
encroachment cases are there, but he has only stated that mentioned 13, only one case number.
No, in one case, RI report and the.
Okay, your lordship can direct only
In
that
that way, the
case.
matter, a direction is issued to the Tahsildar Kujang to dispose of the aforementioned encroachment case number 39 of 2022, if not already disposed of. After hearing the parties, by passing a reasoned order not later than 3rd July 2023. Petition is disposed. A copy of this order be sent to the Tahsildar Kujang. Forthwith.
Item number 16.
May it please your lordship. And the government, in this petition, my lord, the government has proposed to construct a fish harbor project on the banks of Budhabalanga River in the district of Baleswar, my lord. These present petitioners are the villagers of one Balaramgadi village. On their village, this project is going to be constructed, my lord. My lord, I have annexed the map of the proposed project at page number 9, my lord. These villagers have made a representation before the collector, my lord. The present location at which the proposed project is going to be constructed.
Where is that that acknowledgement?
Representation is at page number 10, my lord. Annexure 2.
That signature is the acknowledgement.
My lord.
It's written by hand like this, is it?
Yes.
Okay.
My lord.
Collectorate. All right. The petitioner's representation bracket annexure 2 series will be examined by the collector Baleshwar, and after notice to the petitioners and giving them a hearing, a reasoned order shall be passed not later than 1st June and be communicated to the parties not later than 8th. The court clarifies it is not explicitly.
In the meanwhile, they have started construction of the compound.
Yes.
Item number 17.
May I please? This is a public interest litigation. The cultural land of the village has been fraudulently recorded in favor of opposite part number 4 and 5, and they have also sell away the property from opposite part number 6 to 8. Your lordship kindly see by annexure 1, the ROR of 1928, which reflects that the khata number 1.
Where is the proof of submission of representation? Where is that?
My lord? Yes, my representation is your lordship there. Page 24, annexure 3, my lord.
Where is the proof of submission?
That is not there.
Ah. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to make a proper representation and
Tahsildar Mangal.
after following up such representation to seek appropriate remedies in the courts. The petition is disposed of as withdrawn with liberty spread.
For orders item number 18,
We'll take it at the end of the boards. End of the board.
item number 19, weekly list item number 19,
End of the board.
None appears dismissed.
item number 20,
So item number 20 is concerned, my lords. I have instruction to appear for the respondent, my lords.
Who's for the appellant?
Lordship, item 20 and 21. Really adjourn the matter to chapter. Similar matter is adjourned to 17.5 million.
No.
You are for the appellant.
I am for the appellant. On behalf of Mr. Tripathi, ma'am.
May I pray, my lords? My lords, it is a case of regulation, my lords. The respondent, my lords, have worked for more than 26 years.
Anyway, when are the other matters coming up?
17.5 million.
No, it's not a case of.
Friday, it was there in item number 19. W665 of 22.
Give us the date, sir.
17.5 million.
May I pray, my lords? I have a similar order that can be passed, my lords. In respect of similarly situated person, my lords, a lordship of pass orders, my lords.
Because of the
I'll
personal
just-
difficulty of Mr. Tripathi, my lord, I am.
I'll just pass. Your lordship may kindly see the first date is second order. And the orders have already been implemented, my lords. The respondent had worked for more than 26 years as a typist, my lords. More than 27 years, my lords.
No, but how do you know it's covered by this order? Is this Cashew Corporation? It's not.
No, that is GA
Yeah.
Corporation, my lord, department.
List on 17. Is that an interim order?
Next status quo in respect.
Along with WA number
17.5.
665 of 2020. All right.
The status quo to be maintained, my lords, still then.
So this is his appeal. I don't know why you're asking for status quo. Yes.
20 and 21 both. Item number 22,
My 22, I am permitted to withdraw with liberty to file
I
a
review.
review.
item number 23,
23 same.
Same order.
item number 24,
24 my lord, outsourcing 8th August.
8th August.
item number 25,
At 25 promotion during pendency of that vigilance case, notice not gone, first time it is coming. Lordship may issue notice, they have partly disposal.
No, but we've given a date for similar matters already.
11th May, similar matters have been fixed.
11th May. All right.
26, 27 same.
All right.
item number 29,
Sarat Paridama, 8-5.
8th May. All right.
Notice,
Yes.
8-5.
item number
30
30,
also same.
Yes, yes.
item number 32,
32 sort of.
8th May.
item number 33,
33 also sort of. 8 May.
Yes.
item number 34,
I may please your lordship, my lord. I am in virtual mode, my lord.
Yes.
Item 34,
My lord, this is-
instruction to appear for the opposite party, private opposite party.
I may place the
Copy
fact,
may
my lord.
be served on me.
I may be permitted to place the fact.
And the judgment was passed way back in May 2022. Now 1 year already passed and
This is a
that
judgment per incurium.
that order has
This is
been carried
judgment
out.
per incurium.
Order has been
By-
carried
by
out. My
following
lord friend's client had appeared. Notice was issued before the director and order has been reserved.
My lord, this judgment is a per incurium. Taking the old act, the judgment has been passed. Despite the fact the law has been amended and we have annexed the document that was not taken into consideration.
May I request my
Therefore,
lord to
judgment
give
is
a
no
copy of the order, the judgment, at least the read appeal so that I can.
May I place, my lord?
No, notice is not yet gone in this.
Yes, my lord. Notice has not gone. It is just per incurium, my lord. I'm immediately within 2 minutes I can substantiate.
Also look to the notice which was issued pursuant to the direction of this court, the honorable single judge, and my non-defense client had appeared. Matter was argued before the director, and my order has been reserved. That I have given to your lordships.
That is the order of the secretary also. Why you are suppressing?
The notice which was issued by the director.
Question for consideration is whether the old rule will apply or the amendment rule will apply. Very limited question. I will not go beyond that.
Well, final order is reserved. My non-defense client participated during the course of hearing before the director pursuant to notice, and the order has been implemented. That is what, and the order has been reserved by the director. So I have given the copy of that notice.
So we permit you to challenge that order,
Yes, sir.
raising all these grounds, sir. That's the best.
Well, the director has no jurisdiction. My contention is director has no jurisdiction.
If the director's order is adverse to you, you can challenge all that on these grounds as well.
No. The judgment passed by the single judge directing the director to examine is without jurisdiction of the director. That is my case.
You can
The
challenge.
joint director, by
Sir,
virtue of the amendment
Depending
law,
on, you can't anticipate today what the decision of the joint director is going to be.
no, joint director has been authorized under the statute. And regional director, consequently, he passed the order. And the judgment has been nullified because the director has the jurisdiction, which is an old law.
So the question is, if the director has reserved orders pursuant to the impugned order, whatever orders are passed, if they are adverse to you, when you challenge that order, all these points you raise,
But
including jurisdiction.
I cannot raise the jurisdiction of the director.
Of course you can. We'll permit you to, sir. You can.
Yes, all right, Madam. Let's say that.
It is informed by counsel.
Hearing
Concluded on
22nd February. Hearing.
Senior, Mr. Learned Senior Counsel appearing to the respondent that pursuant to the impugned order dated impugned judgment dated 9th May 2022 of the learned single judge in writ petition civil 16762 of 2021. The Director of Higher Education has already given a hearing to the present appellant, and orders have been reserved. Paragraph. Mr. Kali Krishna Mishra, Learned Senior Counsel for the appellant, urges that the director lacked jurisdiction to consider the case of the
Though he has participated. Yes.
present appellant, and therefore the entire impugned order, to the extent of referring the matter to the director, should be held to be bad in law. Paragraph. Inasmuch as the director has already heard the appellants and has reserved orders,
After hearing both sides.
the court
And no such objection
permits
was
the
given.
appellates, if the order of the director is adverse to them, to raise all pleas to challenge such order, including the pleas raised in the present appeal, namely want of jurisdiction of the director. The writ appeal is disposed of in the above terms.
Obliged.
34 and 35.
35 same.
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 Both.
34, 35 same.
34 and 35.
Same common judgment.
Item number 37.
None of yes dismissed.
Item number 41.
My lord, will find the order at page 46, ma'am. My lord will kindly see at page 48, rule 43 has been quoted, ma'am. Rule 43 of the pension rules. Pension on absorption in or under a corporation and public undertaking. A government servant who has been permitted to be absorbed in a service or post in or under a corporation or public undertaking, wholly or substantially owned or controlled. Now, here, the respondent was allowed to take part in the interview. This is admitted, madam. This is not disputed. He was only allowed to take part in the interview. Thereafter, on being selected, he applied to be relieved. He was relieved. Now, thereafter, he has, my lord, claimed this. our submission to this honorable court is Rule 43 was not complied with at all, my lord. Number one, because we didn't allow it, number one, and there was no public interest involvement. My lord, kindly see the word is very clear. Controlled by the government or an undertaking jointly controlled by the government and central government or by the government or any other state government to be in the public interest. So, my lord, in fact, if I will take, my lord, to the very pleadings of the respondent in the way also, the respondent himself also prayed in the way that Rule 43 may not be strictly adhered to. That was his, or that was, so he also admits that he was not covered under Rule 43.
Yes.
Sir, first and foremost, we had filed a caveat, my lord, and we have not been served with a copy.
All right. Caveator's discharge, he appears. Copy of the writ appeal be served on the caveator. Notice the accepts notice for the respondent. List on. July 18. There should be interim order. Staying the bureau.
My lord, with all due respect, my lord, here the opposite party was very much, the respondent in this case, my lord, was very much satisfying the service period that has been described.
Consider next.
Item 42.
Obligement.
42.
42 is it's covered by that item 11, ma'am. Madam, I'm sorry, ma'am. I'm sorry. Madam, may kindly come to page 60. On the very, this is order number 2, the Honorable Single Judge, my lord, I have also in my writ appeal, I have stated that in 2019 we have paid, my lord. The 75% of the pension dues were released in 2019. In 2021, when this writ petition was filed, the Honorable Single Judge directed for release of pensionary benefits on the very fast rate, my lord, with 18% interest. And by my lord, by filing of this, by the date of filing of this writ petition, we had cleared 90% of his dues, my lord. That was not brought to the notice of this honorable court by the respondent.
All right. Counsel, the appellant contends that 90% of the dues owed to the respondent have already been cleared by the appellant. And therefore, there was no justification for the learned single judge to have issued the orders as such in the impugned order. So notice returnable. August 10th.
Man, obliged.
Item number 43. Item 43.
None appears dismissed.
Item number 44.
44, my lord, your lordship has fixed similar matter to 5th May.
Item 45.
45, 46, 47, 48, same.
Like this one.
45, 46, 47, and 48.
All right.
Item number 49.
49, my lord, Sartapada 8th
May.
8th May.
Item 50.
50, my lord, defeat is there, and next week I will remove the defeat.
Next week. Just on first main, defects be cured.
Item 51.
51, my lord, this is DLR regulation, my lord, 25-4.
All right.
Notice to be returnable. Notice.
Item 52.
52, my lord, here the claim of for UGC, my lord remembers that demonstrator. So, my lord, because my lord's order, in view of my lord's order in state of Odisha versus confirmed in honorable appeals courts.
You have the other similar order? You have passed similar orders.
The Lordship has already dismissed. Allow that and
Where is
it's
that?
please to be.
Just give us the reference.
Yes,
In view of the judgment dated so and so and so and so. The present writ appeal is dismissed. All right.
Item number 53.
53, my lord, that matter, promotion during pendency of the vigilance proceeding and disciplinary proceeding. And the Lord and single judge has disposed of on the same date, directing to give promotion to the petitioner. Lordship batch of matters, so Lordship disposed of, remitting the
First day disposal. Can it go back?
My lord, no, if, no, to the vigilance case and no charge sheet has been filed.
No. If it's a first day disposal,
And copy notes.
this is
are done.
53, right?
Well, 53.
My lord, copy notes are done.
order का देखो रिमांड हो जाता है रिमांड हो जाता है
No, but here I think reply was there, no? The OA?
My lord,
Reply was there in the OA. This is an OA matter.
yes, my lord.
So reply was already there. This order will not apply. Here, this was first day disposal without pleadings.
Okay, step has to though. First day order.
In melody in OA, reply has been filed.
Yes, it's been filed.
Oh, Lordship, I will take notice.
All right. Notice, she accepts notice, reply, copy of the writ appeal be served on her. Please come. Third July, interim order.
Obliged, my lord.
Item 54.
54, 55 outsourcing, my lord, 8-8.
8-8.
Notice to go, man.
Item 56.
56, my lord, contractual driver, not covered by Patita Pavan, it has been disposed upon Patita Pavan Datta case. Page 23, input order.
So then 11 July.
11 July.
11 July. Stay till then.
Item 57.
Order upon under single judge order is challenged, my lord. On the ground that, my lord, that the appellant has not possesses the special training, my lord. So lordship kindly glance the annexure 8, my lord.
I think we've already dealt with the matter like this.
My lord,
We've already dealt with this similar matter, the special training.
yes, my lord.
I think there's a batch of matters, correct?
I have no idea, my lord, that. But he has completed 3 years.
No, it is 3 matters, sir. Why are you saying you're not aware? Come to page 14.
Yes, my lord. This is the singular matter, but
is it not in a batch of matters?
Yes, batch of matter, my lord. And that is, I am one of the appellant, my lord. I am one of the petitioner. I am challenging this.
What about the others, sir? Are you aware?
Others I don't have, my lord.
There is, I think there is a connected matter here. There are 2 connected matters anyway in the impugned order.
The lordship fixing.
Sir, are you understanding what I'm trying to tell you?
My lord.
What have
Your lordship has told that the 2 connected matters is there, my lord. So that should be tagged.
Are you seeing that there are 2 connected matters, or you are not aware of it? Page 14.
Yes, my lord.
And your lordship, I am in writ petition number 27611721, my lord.
Correct. The petitioners in the two connected matters, I think they have filed writ appeals here.
My lord,
Are you aware of that?
I have no idea.
Ah. I'm very sure that affirming the order of the single judge.
I have filed a IA, my lord.
Sir,
IA number 286822, my lord.
better do some homework, find out what has happened in the appeals filed in the
Yes,
connection.
my lord. I will do it, my lord. Your lordship, the IA is IA for I may be permitted to. The IA is there, my lord. IA number 2868, my lord, 22. Next week, my lord, you will be take up. I will check out what is the another appeal status, and I will come
The
back, my lord.
registry to ascertain if any appeal has been filed against the imbue judgment dated 31st May 2022, which is common to two other writ petitions, apart from the one filed by the present appellant, Dr. Chinmay Rashmi Ranjan. In other words, the registry will ascertain if any appeals have been filed by the petitioner in petition civil number 27613 of 2021, Mohanlal Khadia, and 27620 of 2021, Vishwajit Kara. List on. April, 20 April.
Oblige.
Item number 59.
But in this case, my lord, once I took time to remove the defect, my lord, I again pray, my lord, your lordship may kindly grant me some time.
Isn't there here also a similar matter?
Pardon, my lord?
LIC. All right, you see list on 1st May. Defects we removed.
Okay.
Item number 60.
Item 60, my lord, outsourcing. LRC 8th
August.
Item number 61.
61, my lord.
61, my lord, I am appearing for the respondent. Direction may be given to the state to solve a copy of the appeal memo. I'll file counter, my lord.
This is not a first day disposal.
No, not a first day disposal.
All right.
What has happened in this case was initially appointed as a TGT in the year 1984. Subsequently, she was redesignated as and upgraded to the post of TGT in the year 1994. In 2013, he approached the tribunal to grant him TGT scale with effect from 1984. So, Honorable Single Judge has directed as similar benefit has been granted to someone, another person who has approached the tribunal in 90. So you extend that benefit. So that our claim is that after 30 years, he's claiming a benefit which he is not entitled to.
What do you say?
My lord,
What do you say?
I maybe serve a copy of the appeal memo so that I can.
All right, copy the appeal memo be served and counsel with the respondent. 21st June, opening day.
Obliged.
Item number 62.
62, 63 both are outsourcing, my lord. 8th August.
8th August.
Notice.
Item number 64.
64 and 65 rehabilitation assistance appointment. 38. Notice to go.
Yes.
Item number 66.
My outsourcing 8th August.
8th August.
Item number 67.
67, my lord, data entry operator.
Your lordship has reserved for judgment.
Reserve. Put down his name.
Well,
What is reserve?
grateful.
Item 68.
68, my lord, job contract, pension, my lord, have similar matters. 14th 9.
14th?
49.
September.
68. 69 same.
Item 69.
69 same.
68 and 69 same.
68, 69 same.
Item number 70.
70, 71 are promotion during departmental proceeding and vigilance. So, my lord, I will, because first time disposal, first day.
No, but nobody is here.
Nobody is here, so I'll take notice.
11 July. Stay till then.
Item number 72.
72 is my lord outsourcing, 8th August.
8th August.
Item number 73.
73, my lord, Saptaparida.
No, 73 is the appeal preferred by the appellant Lambodar Behra. It's not a state appeal.
Oh, sorry, 74 Saptaparida.
73.
In 73, your lordship, there's some defects. If your lordship will permit me 1 week time, I will remove the defect, your lordship.
All right, list on. 1st May. Defects will be removed.
Item number 74.
74 Saptaparida, 8th May.
8th May.
75. Item 75.
What is it, sir? All right. None appears dismissed.
Item number 76.
76 and 77, your lordships have fixed the matters to 24th July.
Okay.
78, 79. Item number 78.
The lordship may take up 79 minutes. Let me tell you, lordship, what is this case all about? My lord, we in Odisha had a 1980 rule regarding verification of caste certificates. Now then, my lords, comes the Madhuri Patil judgment. Your lordships are aware, 1994, 6 SCC 241. I have given a compilation, but let me tell you, lordship, what the case is. Now, Madhuri Patil laid down guidelines regarding verification and cancellation of the caste certificates issued. And it said, my lord, there will be a committee who will deal with all that, and there will be a vigilance committee.
Correct.
What happens thereafter, my lords? In the writ petition filed, which is Prasanna Kumar Naik, and that is OJC 4251, it's page 24 of the compilation. If your lordships kindly take it up, lords. Your lordships kindly see, my lord, the judgment starts at page 24.
Yes.
And if my lordships are pleased to see, my lords, paragraph 6. My lordships have it, my lords, page 26.
Yes.
Page 26 of the compilation.
Yes.
The state of Orissa framed Odisha Caste Certificate for Scheduled Caste, Scheduled Tribes, Rules 1980. In Rule 6, the authorities who can issue such certificate have been mentioned. Authorities mentioned Rule 7 can be recommended to the competent authority for issuance of such certificate. Sub-rule 2 of Rule 8 empowers the competent authority to cancel the certificate if no subsequent verification reveals that the claim was false. Rule 9 provides for appeal. An appeal can be made before the district magistrate collector if the competent authority is subordinate to him, and the revenue divisional commissioner if the order has been passed by the district magistrate. This was the scheme under the 1980 rules.
Yes.
Then your lordships, refer to at paragraph 7, your lordship referred to Madhuri Patil, and thereafter, my lords, what your lordship says in paragraph 8 of the judgment at page 28, in view of the law laid down, my lords,
yes,
in view of the law laid down by the apex court, the state government was to take immediate steps to amend the rules and issue suitable executive instructions in light of the above law to all concerned to strictly abide by the decision of the apex court. So your lordship said 1980 is now gone. You make new rules in sync with the Madhuri Patil. My lord, what happens is, my lords, if your lordship sees, there was a resolution passed on 1/1/2010, which is page 69 of the compilation. My lordships have it, my lords?
Yes.
Page 69 of the compilation.
Yes.
Whereas the state level committee constituted under the government resolution dated so and so was modified in the government resolution so and so has not fulfilled the objective of expeditious disposal of complaint petitions relating to face caste certificate cases, and this is creating law and order problems in the districts. Whereas 976 complaint petitions relating to false caste certificate of Kandhamal district received by one state level committee, final orders have been passed only in so and so. So saying this, my lord, what they did, therefore, my lordships have that paragraph, my lords. Therefore, in order to ensure expeditious disposal of all complaints relating to fake caste certificate cases, the state in a time-bound manner, after careful consideration in accordance with direction of the Supreme Court in Kumari Madhuri Patil versus so and so, civil appeal number so and so, and in partial modification of the government resolution cited above.
So another committee is set up.
Yes, committee, my lord, was set up. Now, my lord, this committee, if your lordship sees just a little bit, pursuant to the judgment of the apex court, committee has been set up. Now, the grievance is that the learned single judge, my lords, says that kindly come to page 23, that is the impugned order.
Yes.
If my lords kindly sees, my lords, paragraph 4. Mr. Rautrai relies on the judgment of the Supreme Court in Dayaram Sudhir versus Bantham, so and so. He draws attention to paragraph 5 and paragraph 14 of the Manupatra print. He submits in paragraph 5, 3 questions have been framed. Number one is relevant for adjudication of the question number 1, whether directions in Madhuri Patil are impermissible, being legislative in nature. Therefore, then Lord, paragraph 14 is quoted. Therefore, we have the view the directions 1 and to 15 issued in exercise of powers under Article 142 and 32 of the Constitution are valid and laudable as they were made to fill the vacuum. Kindly note the word, not vacuum. And in the absence of any legislation to ensure genuine scheduled caste certificates of scheduled tribes are secured, the benefits of reservations and so candidates are kept out by issuing such directions. Then the submission is, he submits that above a judgment of Supreme Court in Kumari Madhuri Patil, reported in so and so was delivered in exercise of powers of 142 of the Constitution of India, as clarified by Dayaram. Hence, it is applicable to those states where there has been no legislation on the issue. In Odisha, the 1980 rules prevail. Subordinate legislation rules is also a legislation. In the circumstances, SLC did not have jurisdiction. But what Dayaram said was that if there is no law, obviously no law in sync with Madhuri Patil, and 1980 rules, your lordships have already said it is absolute.
Or we should notice.
Lordship.
Say notice till the next day there should be a stay.
My lord, I'm praying for an interim stay of the judgment.
Just said.
Grateful.
List on.
My lord, both 78 and 79.
Right.
Deeply obliged.
List on 5th July. 5th July.
Great.
5th July. Before taking hearing matter, my lord, your lordship dismissed item 1 for
1 minute, so we are just finishing.
I am permitted to withdraw it for filing a press application with liberty.
Item 1, counsel the appellant seeks leave to withdraw the present petition with liberty to file a fresh petition. The post office is withdrawn with liberty spread.
For admission, item 80.
80, my lord, permit to withdraw.
All right. This post office withdrawn.
WPC number 13995. To
Or-
contempt matter 232.
All right, both. And 15660.
So far other writ application is concerned, I am appearing for the opposite party. I think that become infructuous.
Infructuous, okay, disposed of. Corrected matters are all dismissed.
Item number 81.
May I please, Your Lordship? Plus, we are extremely grateful to Your Lordship for Your Lordship's active guidance. In the meantime, 170 tons of ganja has been destroyed.
Oh, very good, very good.
And Your Lordship will get the exact figure from the paragraph 2.
Okay. Yes.
Plus 1691 kg, 60 quintal, 60 kg, and 920 grams of ganja, and 62 kg, 03 gram, and 270 milligram of brown sugar, and 94 kg, 494 gram of poppy straw. These all are destroyed. Loss.
All right.
And paragraph 3 already, and also unidentified drugs, that is to the tune of 22 quintals, 93 kg, that has also been destroyed. And Your Lordship get from paragraph 3, that is ready to be destroyed, that is 406 quintals and 33 kg and 171. And process is on regarding the other pending cases.
All right, the compliance affidavit has been filed today by the SP Special Task Force CID Crime Branch Orissa, in which it is stated in para 2 that pursuant to the order dated 21st December 2022 passed by this court. A to A. The above efforts will be continued in the same letter and spirit, in the same vigor. A further updated status report in the form of affidavit will be filed by the next date.
And before parting, loss, may I humbly just bring to loss.
Yes, please.
That is, plus state is even very much obliged to Your Lordship for the appreciative words Your Lordship was used in the paragraph 2 of the last order.
List on. July, 20 July.
Plus one more prayer, plus may I humbly pray. That is, plus STF is working at the special wing of the government, special task force. So I humbly pray for a happy note so far as STF is concerned. Plus. I humbly pray, plus most humbly.
All right. Good work is the court records the good work done by the STF. All right.
People oblige, please.
All right.
Item number 82.
I may be pardon, my lord. I am in the witnessing, lord.
Yes.
Lord, your lordship may kindly have a look at order dated 14/9/2022, lord.
Yes.
14/9/2022. Direction has been there to file all the objections by all the parties. Only opposite party number 6 and 7. They filed objection day before yesterday. I received the copy.
All right. It stated that.
And others have not.
I may kindly pardon me, lords. My lords may kindly see the cause list, noting in the cause list, my lords. Because, in fact, there is a little mistake. Your lordship directed the petitioner to file a copy of the writ petition on me, my lords. But the order is reflected in the corrected writ petition. It should have been there in the past application. It is a subsequent writ petition which they are supposed to pass. They are not given. So I couldn't respond. So let me direct them to give a copy.
All right. In 1149 of 2022, you should copy this writ petition. Be copy the writ petition, the present of the present writ petition. Be provided to counsel appearing for opposite party number
7. I am opposite party.
7. But you've already filed a reply.
That's the second one. In the first one, your lordship directed to give a copy so that I will respond to the petitioner's writ petition.
6 and 7, I am appearing for sale, where we have filed the response in the first writ
OP
petition.
number 7 in WPC number 5100 of 2021.
That's
there is a noting your lordship have directed.
No. So you want a copy in which one, sir?
I want a copy in the first one, 1149 of 22 minus.
Who are you appearing for in that?
Yes, I am appearing for Ferroscrap Nigam.
I think 5 and 8.
5. Okay. Counsel,
5 and 8.
Be served on counsel appearing for opposite parties 5 and 8.
Yes.
To enable them to file a reply within 4 weeks.
Lordship, in item 1114.
I'll do that.
The writ petition 1149, I appear on behalf of Mr. Shashwat Acharya. We are for the OP9.
All right.
We'll file a wakalatnama and counter
Counsel
the
for
appeal.
opposite party 9 also undertakes to file a reply within 4 weeks.
So interim order to continue, my lord.
Interim order.
Deeply obliged.
Let's
Obliged,
on.
Lordship.
Lord, the appearances will just, if your lordships will permit, we'll just give it.
I know.
So that
Please,
it will
please.
be
There's no
easy.
confusion there. Correct. List on 14th August.
Obliged.
All right. That's
Obviously.
Item number 83.
83, my lord, I am for the petitioner. Today I have received the copy of counter, your lordship. Some date may be given. Few dates. What is it?
I have filed counter affidavit, Your Lordship, OP number 5. I've served a copy on him.
joint junk irritation.
He is questioning, my lord, the rotational distribution of water by the by that dam, my lord. That is in consonance with my lord Pani Panchayat Rules 27B. This is being followed since 2002. In fact, in another matter also, my lord has disposed of a matter recently.
Correct.
Holding the resolution, holding the resolution to be the correct procedure to be adopted while in connection with distribution of water.
Say judgment of the woman.
Correct. And year after year, my lord, when our turns come, the other side they go and protest. Your lordship had also seen in that case 20 or 30 FIRs were lost by the public officials because my lord's order is at page 11.
Is 13?
13 is the relevant portion.
Recently, your lordship has dealt with similar issues, and this is that.
Correct.
And Chief Secretary also, the Secretary also, whom your lordship directed to take note of, and against which he is here, that also has taken care of all these things, my lord. That your lordship would find.
So this is already covered by this order then.
Covered by this order, and in fact, the lordship had directed the Chief Secretary to take a decision. That is at page 51. He also inconsistently says that this is rotational basis is the best way, and only way rather. That your lordship would find at page 50 of the writ petition.
Today I have received the counter copy, your lordship. Now, just now, your lordship.
It's all right. The issues raised in the present petition about distribution of the waters of in the upper Jonk irrigation project was already the subject matter of writ petition civil PIL 3356 of 2023 bracket Birbal Maji versus State of Orissa, in which an order has been passed with this court on 13th February 2023. For implementation of the decision of the advisory committee.
That is also for the same district, Noapada.
Yeah.
Here the.
And that too in the same district of
Same place, same
dam.
All right. In that view of the matter, no separate directions are called for as far as the present petition is concerned. The present petition is also disposed of in terms of the above order.
There is a
connected matter is there.
Yes. Disposed of in terms of that.
Connected also goes.
Yeah.
Tunuram Sahu.
Correct.
Same connect.
Item 84.
Yes, my lord. May I please, my lord? My lord, in this case, my lord directed the government to file the affidavit regarding the benchmark value. So far as I am recollecting the memory, my lord, In the past day, my lord directed that the government should file counter affidavit to show that what is the benchmark valuation of the area. The government has also filed counter affidavit. Endowment Commissioner has also filed the counter affidavit. My lord, may kindly see.
My lord, in this case, my lord, he has approached in a PIL to set aside a sale deed.
It is
To set aside a sale deed, my lord, in a writ petition. And as per the direction of this honorable court, the endowment commissioner has given the benchmark value when the land was sold, my lord. At that time, the 1,62,700 per acre was the benchmark value. But the petition, the opposite party have purchased 15,40,000 per acre, my lord. When the benchmark value is 1,62,700, but he has purchased, my lord, 15,40,000, my lord.
Here the
And the sale deed is, my lord, executed in a writ petition. Can your lordship
No,
set
it is
aside
not.
the sale deed?
My lord, it is not the prayer of the parent. My lord, it is here in the case is that section 19 of the endowment of the OHRE case, OHRE Act, section 19 clause 5, that the appellate authority cannot reduce the benchmark value. That is the question, my lord. My lord, 19 clause 5.
The benchmark value is 1,62,000. The
let me
affiliate authority, my lord, have fixed it to 3,40,000. And it was sold on 15,40,000.
Yes. I am submitting, my lord. The appellate authority cannot reduce the when it is not a inadequate. That word is there. The word is that when I am reading that clause, my lord.
What's the point, sir? Here the sale deed says that the amount paid is 15,40 per acre, 15,40,000 per acre.
40,000.
My lord.
Much higher than all these values.
My lord, that is not the case, my lord. My lord is the my lord page 3 of the counter affidavit of the government. Page 3 of the counter affidavit, my lord. The benchmark value of the land is now it is 1,99,94,000.
You have to see at the time of sale.
My lord, that sale was in the year of 2022.
Correct.
20. That is during the Corona period.
Whatever,
At
sir.
that time, yes, at that time, the benchmark value was 15,40,000, my lord.
Correct.
But the land was not sold at that rate.
It was, sir.
No, my lord.
Yes.
My lord, 6 acres land was sold only.
Registered sale deed, the transaction value.
It is only 50 lakhs only for 6 acres, my lord.
No.
Yes,
Per
my
acre,
lord.
sir. Per acre.
My lord, no, it is not the fact. My lord, it is the sale price. It is the sale deed. The sale deed was executed on 27 May 2020 with 50 lakhs. That is only 8 lakhs per acre.
Can it go in the writ application, my lord? When they have filed the
The
affidavit.
submission is wrong. It is not 50 lakhs, but it is 8 lakhs. When the
This all
benchmark
will be matter of evidence, sir. An affidavit has been filed by the sub-registrar placing on record the benchmark values for the years 2020-21, 21-22 and 22-23. So it is seen that the registered sale deed was registered. The registered sale deed was at the basis of the plot value being rupees 15,40,000 per acre, whereas the benchmark value at the relevant time was rupees 2,58,800
No,
per
it was
acre.
15 lakhs. It was 15 lakhs 40.
15 lakhs.
Benchmark value was 2,58,800, sir.
My lord, the sale deed was executed in the year of 2020.
Correct.
Yeah,
In that year, the benchmark value was 2,58,000.
8,800.
800.
That was the benchmark value.
Yes, my lord.
Paragraph. Counsel for the petitioner
2021, my lord.
aggrieved.
My lord, 2021, 15 lakhs 40,000, my lord.
Where are you reading?
Yes, my lord, this is the counter affidavit, my lord.
Correct.
No. Yesterday I have filed the
1920.
No, counter affidavit filed yesterday.
Yes, my lord. 1920, it was the benchmark value of 2,58,000. But 2021, it is 15,40,000, my lord.
I don't know where you're reading, sir. I'm reading annexure A4.
Annexure A3 of the
A4, 20th March 2023.
My lord. Just a minute. Yes, my lord, it is also there. A3, 2021, 15 lakhs.
A4, sir.
A4, page 3. Yesterday's affidavit.
A4, page 3.
8 again.
Yes, my lord, this is also I am reading. That is a 2021, 15,40,000, my lord.
First, read carefully, sir. Read from top. What is written in the background?
Bottom.
Read in the bracket.
My lord, the benchmark My lord, I am submitting that. I am also reading that aspect. I am coming to that aspect, my lord. The benchmark value of this plot is 2,58,000, but in the RSD, registered sale deed, the transaction value is 15,40,000, which was taken as a benchmark value for that year, my lord.
No, that is not taken.
No. All right, that is not.
That is
The petitioner, however, disputes the above valuation as well. Clearly, these are disputed questions of fact. So if the petitioner wants to challenge the validity of a sale deed on the basis of its valuation, then the appropriate remedy would be to go to the civil court for that purpose, since evidence will have to be led by the parties to enable the court to ascertain what the correct benchmark value was at the relevant point in time, and whether in relation thereto, the valuation of the sale deed is appropriate. These are not matters for determination in a writ petition. Leaving it open to the petitioner, if so permissible in law,
with that,
to avail of other civil remedies, the court declines to interfere in the present petition. It is disposed of as such.
Item number 85.
There is an interim order, my lord.
Interim order stands vacated.
Item 85, it is regarding that PET CT scan. If a lordship will, there were two parts of the last order, my lord. One was with regard to the status of installing the PET CT scan at Jharsuguda and Bhubaneswar. As far as that part is concerned, they say Bhubaneswar, it will take at least another 2 years because the civil is going on and they have not given any deadline. But whereas on 29th of April 2021, they said it will be done in 2 years' time, which has already expired, my lord. That is as far as Bhubaneswar is concerned. And with regard to the Jharsuguda, if a lordship will see the affidavit dated 24th February 2023, they are totally silent as to what is the status with regard to installation at Jharsuguda. Now, as far as Jharsuguda is concerned, there is an operational airport functioning for over a year now. So there should not be any difficulty. But the affidavit is totally silent as far as Jharsuguda is concerned. So this is as far as the Jharsuguda and Bhubaneswar is concerned. Now, Baleswar and Berhampur, this affidavit states of 24th of February that if there is no airport in the same city, it is not possible. Now, as far as Berhampur is concerned, now Berhampur also has an airport for last almost about 15 days or so. So with regard to Berhampur, they should not have any problem, my lord.
Jharsuguda and Berhampur both have airports now, sir.
Now, recently it has been.
No, Jharsuguda is for some time.
Jharsuguda is for some time.
Berhampur recently.
Sir, yes, I filed this affidavit on 24th of February. I would request my friend to what are the he wants that he can file an affidavit so that I can respond giving the details. If you can take steps or at Jharsuguda, so also at Berhampur.
At least let these two places begin, my lord.
Hey, please let him indicate those.
What best can be done.
We'll put in the order itself, sir.
Yes,
it's pointed out. Yeah, it's pointed out, Mr. Gautam Acharya and the senior counsel for the petitioner, that there are airports both in Jharsuguda as well as recently in Berhampur. And therefore, the stand of the state as expressed in its affidavit dated 24th February 2023 regarding provision of PET CT scan facilities in both places requires to be revisited. Mr. Samantrai, and counsel appearing for the state, undertakes to file a further affidavit after once again examining the matter of the health secretary, of the principal secretary health, who will once again review the matter in light of the above development.
Now, as far as Baleswar is concerned, my lord, just have about a traveling time of about 2.5 to 3 hours. So that does not have any difficulty because they are getting it either from Calcutta. If it is being brought from Calcutta, Baleswar is about 3 to 4 hours.
There is an airport in Kharagpur, I think, now.
Not yet, my lord. I don't think. But in any case, whether it is Calcutta or Bhubaneswar, Baleswar is halfway, my lord.
Correct.
It will take more than 4 hours. So that also should be considered.
Even as regards Baleshwar, since the distance by road, both from Calcutta as well as Bhubaneswar, is under 3 hours. The stand of the state government, even in regard to that city, requires to be revisited. And then say a further affidavit be filed by revisiting the stand in respect of all 3 cities before the next date.
My lord, I have got small submission to be made in this case, my lord. Maitri Sansat is a later petitioner in this case, ma'am. In this particular case, we have filed an interim application, ma'am. Interim application is pending. In spite of your lordship's order and direction in order number 14 dated 19 October 2022, I may be permitted draw your lordship kind attention para 5 of the said order. This honorable court has directed to give reply to the interim application, but as yet no reply has been given, my lord. In meanwhile, 5 months have already been elapsed, my lord. May I pray, my lord, necessary order and direction may please issued. They should file a reply to that interim application.
Okay, this is IA 1176 of 2022. Till date, no reply has been filed by the Department of Health, despite earlier orders of the court. A last opportunity is granted to file a reply to this IA positively before 1st July 2023.
My lord, cause of action arises and issue still survives.
Right. Based on 11 July.
11 July.
Obliged, ma'am.
Mobilized.
But I'm there for OP number 3 on your flight.
Item number 86.
My lord, this PL is pertaining to the release of vehicles from stacked in police station.
Last affidavit I have filed on 31st March. The copy has been sought. I have given the figures. Lordship may see the affidavit dated 31st March filed by the SP Deputy Superintendent of Police CID Crime Branch. Achi, achi tampa hai. Huh? Nabo. Ne.
What is it?
Achi. Paragraph 3 may kindly be seen that it is humbly submitted that in compliance to order so and so, intimate by this office letter number so and so and number so and so to constitute auctioning committee comprising of SP as chairman, one officer of the rank of DSP, RTO of the district as member of conduct auction on claimed vehicles expeditiously as per the guidelines, copies of those. So we have already constituted committee chaired by the SP of the respective district to dispose of all these unclaimed, that is called auctioning committee.
No, but that was long ago, sir. See, 30th November also, there were 2,742 vehicles to be disposed of. What has been disposed of after that?
Yes, that is there. That it is humbly submitted that total 2,742 unclaimed vehicles were lying in different police stations of the state as on 30th November 2022. Out of the same, 1176 vehicles have been auctioned and sold by 31st March 2023. Further expedited, this is the figure. Annexed B by 3.
Can you give us another copy of that 31st March? When have we listed the other matter?
This affidavit was filed on 31st March.
All right.
Last.
An affidavit dated 31st March 2023 of the BSP CID Crime Branch has been placed on record. It is pointed out that auctioning committee has been set up. No, instructions have been issued for constitution of an auctioning committee at the district level in each of the districts. It is further stated that of the 2,742 unclaimed vehicles lying in different police stations as on 30th November 2022, 1176 vehicles have been auctioned off by 31st March 2023. And expeditious steps have been taken for the disposal of the remaining 1566 vehicles. A further affidavit will be filed before the next date, updating the status of the progress and disposal of the vehicles. List on 28th July.
28th?
20.
20th July. Item number 87.
Milord, in this case, on last occasion, on dated 29th March 2023, alleging the facts and quoting the last order of this Honorable Court, dated 9 January 2023, the petitioner filed one affidavit. After filing of that affidavit, the video has started the road construction of road work and the protection wall for the cost of rupees 6 lakhs out of Panchayat funds. But so far the direction given by this Honorable Court to the state government is concerned, they have not complied it. Nothing funds has been released, and with regard to that fact, they have remained silent.
I'll additional affidavit. Yesterday, the copy has been served on me. I'll take up-to-date instruction, or also give me 10 days time.
An additional affidavit dated 29th March 2023 has been filed by the petitioners, stating that till date, no funds have been sanctioned for execution of the work. And that the village road is still in dilapidated condition. It is seen that a specific direction has been issued by this board on 9 January 2023 in the above regard. The block development officer Bhadrak bracket video will file an affidavit not later than 17th April 2023, explaining how the order dated 9 January 2023 has been strictly complied with. List on 19th April. A copy of this order shall be sent forthwith to the BDO Bhadrak for compliance. The BDO Bhadrak is directed to remain present in virtual mode on the next date.
Item number 88.
Cold storage. Earlier it was taken up in a different tariff rate. Subsequently, in the year 2008 and 9, it was classified in another tariff rate, agro-industry based. Thereafter, it was treated as an allied agro-industry based. I claimed the benefit in respect of that, and these benefits were not extended to me. Subsequently, on the agreement executed in the year 2011 and 13, these benefits are given. I am claiming the benefit in that rate. In this connection, my lords have already dealt with the matter. In one that writ of in writ appeal number 419 of 2013 mailers disposed upon 24/8/2022, and that too basing upon all the decision of our Honorable High Court, the that Odisha Electricity Regulatory Commission also already dealt with that aspect. Kindly that a single order I just not today I got it. I'll file it in form of an affidavit for my lord's consideration. Kindly have a grant that. The only contention is that I have not applied to them, and that is what they have not done it. But it is an automatic process. Even otherwise also I applied that the GRF and the commission has dealt with. My lord's decision and the OERC, basing upon the decision of all the decision of our High Court, OERC has decided. Last portion. One copy with the due humility matters, one copy just now I got it and I filed it. I will file in the form of an affidavit so that it will be easier for my lords to go through and dispose it of. Last paragraph.
This order has been upheld by us.
Yes, my lords. In one case, the honorable court said that yes, they are entitled to the benefits. But in another, that was prepared an appeal in another, in our case, it was rejected.
Takes to place and record with an affidavit.
Yes, ma'am. So I'll file it in form of an affidavit so that it better for my lord's
Orders of
purposes.
the OERC, is it? What is it? Yes. OERC as well as order dated 22nd July 2013 of the OERC, which was affirmed by this court by the dismissal of writ appeal number 491 of 2013. Bracket Executive Engineer Electrical versus Mayurbhanj Cold Storage Private Limited. Bracket. The affidavit be filed.
It's not affirmed. This is one case, my lords, independently, my lords dealt with an affirmed. Subsequently, my lords, OERC taking note of all the decisions of our High Court has come to the conclusion. These are two different cases, but the lawful dissent.
Order passed by us in Mayurbhanj that.
Yes.
Does it not affirm this order? The OERC?
Yes.
No, but
Honorable, earlier decisions of the Honorable High Court has been taken note of. One copy, my lords, that is what I have given to my lords. It is better if my lords I can file an affidavit so that my lord can
all
go
those
through it.
details. See, counsel for the petitioner seeks to place and record certain orders of the OERC as well as this court in the form of an affidavit. The affidavit will be filed not later than 26 June 2023.
Fixing it, my lords.
List on 5th July.
Your lordship fix it to
5th July.
Fixed it, my lords.
5th July, sir. Item number 89.
Lord, in 89, I'm appearing today on behalf of the respondent in this writ appeal, my lord, regarding the arbitration proceeding which has been initiated. So your lordships may give me some time if a small reply.
Notice had been issued.
Notice has been issued.
All right. At the request of Mr. Nanda, who appears for the opposite party. Respondent. Sir.
Respondent.
List on.
Short date we fixed because
Short date.
small point is involved in fact. Because arbitration proceeding has been stalled.
22nd June. All right.
Item number 90.
90 matter similar matters fixed to 25th April.
Pastor matter, item number 18. Item number 18. 18.
18.
Yes, madam. 18, my lord. Lord, I have appearing from the proposed opposite respondent number 3, my lord. I have filed a petition. I have been called upon to show cause on the limitation matter and on the substitution and abandonment. My lord, there is a delay of 6 years, my lord, and 6.5 years, my lord. 2,210 days. I have not been substituted yet. I am the landowner and my opposite partner is my purchaser. That is 2,210 huge days of delay.
It's good you have appeared, sir. Today is a good day to argue.
I have
to argue.
That's correct, but I have to brought in the record. My father is dead.
You are very seasoned, sir. You are very seasoned.
Right,
You can easily argue.
you have the adequate
Just
knowledge.
do one small favor. You sit down, hear the arguments, your arguments will start flowing.
To assist your lordship, my lord, before my learned senior begins. Lord, I have prepared a convenience compilation with an affidavit, my lord. Lord, I may be permitted to give it to your lordship.
Yes. I have got
I have already given to your lordship, but I have served a copy on my learned senior.
Right.
But they have filed a bunch of documents actually I have not seen, but nevertheless, my lord.
But I have filed the writ appeal, if your lordship will appreciate, that I have given the chronologically fact with date chart.
Right.
In the writ application.
Right.
But to apprise your lordship about the irregularity or illegality that has been committed,
right.
If I can, lordship, permit me to read a few paragraphs that will clarify the exact point which is involved in this case.
Right.
But page 3, if your lordship turns.
Yes.
Of the writ appeal.
Yes.
(1931), fellowship kindly mark. Serial number, page 3. The relevant date chart on behalf of the petitioner, Lord.
Yes.
CS, this Sabik record of right of 1931 settlement of Mauja Bahar Vishnunagar, Khata number 917. This is important, Lord. This Khata 917 is relevant for the purpose of the case. Lot number 113583776. Total 606 decimal. It recorded Puratana Patita, recorded in favor of Cuttack municipality with the owner, original recorded owner Bharat Samrat is personal. In the first part, Khewat number 32. It may be noted here that respect of private Jamidari land, the term Mahala was being used. Here it has not been used. Municipal CS Khata number 917 consists of 41 number of plots. Total area is 25 acres, 80 decimal. The 87 record of right, or the HAL record of right, that also is Khata number 118, corresponding to part plot number 283, 231 decimal, 286, 128 decimal, 296, 108 decimal. In total, in favor of Cuttack municipality with note of illegal possession in respect of Navkumar Acharya. The corresponding HAL plot has been given, Merit. History of the case, if your lordship looks at, they said Navkumar Acharya claims that Sabik plot number 113583776, 606 decimal, pertaining to Sabik Khata number 917, Mauja Bahar Vishnunagar, belongs to him as an intermediary. Let's be kindly mark. He claims as an intermediary under Tauzi number 2499. But Tauzis are all recorded in the name of landlords, but ex-intermediaries. The Tauzi number is given. The additional Tahsilar in OEA case number 3699 of 76, by order dated 7/1/1978, settled the land in his favor on section 6 and 7 of the OEA Act. Navkumar Acharya has sold corresponding HAL plot number 283, part 286 and 282 to Govind Prasad Patnaik, who is now contesting party, and by Sari Mahanti, the other case, the contesting party. Thus, the purchasers have claimed land to be recorded separately in Sthitivan Khata. But the municipality case is Sabik Khata 917 at page 4.
Yes.
Pertaining to Mauja Bahar Vishnunagar has been recorded in favor of Cuttack municipality 31 record of right under Bharat Samrat. Part 1 of the Khewat is not under Tauzi 2499. This Khata is not in Tauzi number 2499, which belong to the ex-intermediary. And as per the suit plot 113537776 pertaining to Sabik Khata 917, never vested to government under OEA Act. Am I clear on that?
Yes.
Since it doesn't belong to the Tauzi, question of vesting doesn't arise. OEA Act is not applicable. The additional Tahsildar fraudulently passed order on 7/1/1978 to settle the municipal land in favor of Navkumar Acharya on section 6 and 7 of the OEA Act, which is not within his jurisdiction. The order was passed in OEA case 3699 of 76 as per I report, which was not on the basis of fact settlement made behind the recorded owner, Cuttack municipality. But if you look at, I have given the Tauzi 2499, which he claims. But that Tauzi consists of 3 khatas. Khata number 693, Khata number 694, Khata number 695.
Yes.
102499 West in government on 14/9/1953.
Yes.
But the same doesn't include suit khata 917.
Yes.
Am I clear, my lord? But which belongs to municipality. But OE Act has nothing but the settlement of OE Act is nothing but a nullity. OEA case record is not available for perusal and action. That record never exists. Thus, the claim of Sri Govind Prasad Patnaik and Baisali Mahanti on the basis of the purchase from Navkumar Acharya is absurd and baseless. Creation of other documents, order pursuant to OEA order, will not hold good after the OEA order is found to be fraud by the collector Cuttack in RMC so and so. So an inquiry was conducted. Inquiry, it was collector found no such record is available. And collector has also taken action against the person concerned. Kindly look at page 5, my lord. In 81, Navkumar Acharya filed objection case 3654 of 81 in rent camp settlement to record his name before the assistant settlement officer. Navacharya in 1983 claimed that the additional Tahsildar Sadar has settled the case land under section 6 and 7 of the Act. Their entire case is on 6 and 7 settlement. London Assistant SO partly allowed the objection case in Hall plot so-and-so, originally the corresponding Hall plot number so-and-so. He has mentioned here Hall plot 283, 133 decimal, Assistant SO directed to record in favor of Navacharya in a separate Sthitivan Khata by deleting municipality Khata. All these plots merit. Then 83, CMC preferred an appeal. That is 16873 of 83 by the settlement of Semerald. 1410/95, additional SO allowed the appeal, observing that additional Tahsildar has no power and jurisdiction to settle the municipal land, section 7 of the Act. Same is not valid as such settlement of municipal land is nullity. Sir, 87, despite the aforesaid order, settlement in the settlement appeal, Navacharya sold the land. Even after passing of the order, the land has been sold when it has been heard that he doesn't have the right to the property and cannot be recorded in his name. Those said deeds were during that time, 1410/1885. But 87, in the Hall record of right bearing Khata number 118, published in favor of Cuttack municipality, note of illegal possession was noted. But at 95, after about 8 years, publication in Hall record, mutation case has been filed and claimed title on the basis of OEA order 7178. He wanted to mutate the name on the basis of the sale deed. Sir, mutation has been effected that Hall plot 282. Kindly, interesting is kindly similar. Hall plot number 282, that is the top first one,
yes,
is only 99 decimal.
Right.
Out of which 140 decimal is not possible to be sold. They claim 140 decimal out of 99 decimal. That has been recorded. In 23/1996, mutation proceeding and a petition was filed by CMC with the Tahsildar to call for the disputed OEA case record. We filed an application to call for the record. Tahsildar directed office the production of the same by 17/4/1996. Due to non-availability, OEA case record was not produced.
From then onwards, that same story.
Yes, my lord. Then, my lord, kindly see, in 96, both mutation cases were allowed. In spite of objection, in spite of no such record is available. Peculiarly, though the claim purchaser filed mutation case in respect of total area of 316 decimal, Tahsildar illegally allowed mutation of 438 decimal. 316 decimal claim, 438 decimal is allowed, without giving in reference to the sale deeds. But despite protest, Tahsildar has illegally granted pata, creating separate Sthitivan Khata in favor of purchasers.
So the sale deed itself says only 316 decimal.
Yes, that was the claim.
Mutation is granted for 438.
Yes. But these are the irregularity, illegality committed by the authority. Then, my lord, CN number 15996, certified copy of the OEA case record proceeding was applied for. It was not available to CMC as yet. Till date, no copy has been given to the municipality. CMC preferred municipal mutation appeal 87, 88, 89 before the sub-collector. Sub-collector illegally held the same to be correct, only on the basis of that OEA order. 98 referred MRC number 20, 21, 22 for the Board of Revenue, same as numbered as so-and-so. In the meantime, on 22/8/2009, the above cases have been disposed of by the London Member Board of Revenue after hearing the counsel for both parties that after analyzing the law on the subject, please to allow so-and-so in the process set aside the order of the Tahsildar as the order of sub-collector Cuttack so-and-so. All those cases were set aside by the Member Board of Revenue.
Then single judge.
But since mutation authority like Tahsildar sub-collector in which no record was available, CMC filed a petition before the collector Cuttack to cause an inquiry in 1998. Since such record was alleged to be fraudulent, not available for perusal, the learned collector called for the record, caused inquiry. The fact remained that the said OEA order dated 7/1/78 was passed by the additional Tahsildar behind the back of the CMC without making it a party. Collector caused thorough inquiry regarding the missing record. District Revenue Officer submitted inquiry report on 5/4/2000. The ADM Cuttack submitted his inquiry report on 25/7/2000. The London collector prima facie found that fraud was committed in the said OEA case number 373699 of 76, on the basis of which purchasers claimed title to the municipal land. Collector passed preliminary order on 23/6/99, finally on 26/9/2001, the said RMC 4 of 98. Collector have found his subordinates committed wrong in mutation cases on the basis of the fraudulent OEA case record. He directed for filing cases before him against mutation order passed by the Tahsildar sub-collector pursuant to the said order dated 26/9/2009. The CMC preferred RMC 8 of 2002, 9 of 2002, and 10 of 2002 in the court of collector Cuttack, which is now sub judice. However, OP number 3 have challenged the order of the collector dated 26/9/2001 in writ petition bearing 15822 of 2001, which is, I think it is still pending. I don't know. But in 2001, even though the 87 ROR CMC was changed by the Tahsildar, the aforesaid purchasers, namely GP Patnaik and Vaishali Mahanti, got pata in their favor, filed RP case number 2161 of 2001 and 2162 of 2009 in the court of CLR, and praying to correct the municipal ROR of 87 bearing record of right 118 in their favor. Admittedly, by then, the Tahsildar had issued pata in their favor. Ground was taken that the purchased land from Navkishore Acharya, in whose favor land was settled in Section 7 of the OEA Act. In 2002, December, the aforesaid 2 RP cases were taken up by the court of London CLR, and the purchaser did not make their vendor Nabacharya a party to the proceeding. It was contended by the purchasers, though through their lawyer Nabacharya died issueless. Now he has appeared, his son has appeared in this case. As no documentary evidence was filed in the respect of revision, were dismissed for non-gender of necessary party. Those revisions filed was dismissed. But 2003, after creation of the post of Joint Commissioner, the London Joint Commissioner illegally exercised power, directed restoration of those cases. Those were dismissed, and now it has been restored again in 2003. RP case 2161 of 2001, 2162 of 2001, which are renumbered RP case 1612 and 1613. The purchasers again submitted Nabacharya is alive. He has legal heir. No notice was served on Nabacharya. In 2004, the aforesaid RP cases were allowed by the London Joint Commission in favor of the purchaser and to the Court of Appeal on the basis of the order dated 7/1/78. That was the basis on which RP cases were allowed. During pendency of the case, Higher Authority, Member of Board of Revenue, as well as the High Court. OP number 3 filed counter affidavit with a copy of the deregister. But now the interesting part comes, Malad. Deregisters are maintained in the Tahsil office, Malad. Deregister contains the name of the intermediary and the tenants who are there in the position. But it is humbly submitted that London Joint Commissioner misread deregister 1000 number 2499 regarding entry of Privy Council decree. 1930, a Privy Council order has been passed. The Tauji number 2499 consists of 3 Sabiq Khatas, 693, 694, 695. This khata doesn't find place there, my lord. Again, I am repeating, my lord. The khata under which the municipality claims is not within that khata. The deregister, it revealed that 16 anna share of Gajendra Acharya and Padmanabh Acharya was reduced subsequently due to Privy Council decree, civil court sale, purchase and partition. It reveals from the deregister that pursuant to Privy Council decree, in Fakir Dibya, wife of Abhinyu Acharya, was allowed 6 anna share in mutation case so-and-so, while sharing the original recorded owner Gajendra Padmanabh were reduced to 10 anna share in the aforesaid mutation case. But at the deregister entry has been quoted here. But I will take your lordship, I will not take your lordship, the Privy Council decision is 1930 Privy Council. I have given the summary of it. If your lordship looks at page 12, Tauji number 2499, which was there in the deregister. It says Kasinath Mahanti, Common Manager, Siddheshwar Estate, Kasinath Mahanti, Common Manager, behalf of so-and-so. Then the next page, but the Tauji 2499 has no nexus with the municipal khata 917. The said order passed by the London Joint Commissioner in RP case has been challenged in writ application 1211 2006 and 12032 of 2006 along with prayer relating to OEA order is void. OP number 3 also doesn't come with a ambit of OEA lease principle or government order in 1964. But the case sub judice is OEA revision 10 of 2009 before the Board of Revenue, where the OEA order was a challenge. But that order has been challenged not by obtaining copy. Copy has not been given to municipality. We annex the copy supplied by them, which they say that we have got a certified copy, but the original is not there. That order was annexed in the board before the Board of Revenue, challenging that the OEA order itself is bad because there is no such record available and it's a fraudulent entry. This khata doesn't come within the Tauji, question of settlement doesn't arise, vesting doesn't arise. But in that case, that revision case 10 of 2009, further proceeding has been stayed. But they have challenged a writ application before the Honorable High Court. They have filed a writ application before the Honorable High Court. That is, I think, WPC 12031. Just 1 second, Bharat. Yes, 10687 of 2016. The OEA case which was challenged before the Board of Revenue, that has been stayed, which could have examined the matter with regard to the validity of the OEA proceeding. But now, on the basis of this document alone, the only document is that now they have rely on that OEA order. On that basis, the settlement record of right has been corrected. But interestingly, all these points were raised. If you kindly look at page 15, the plot numbers are there. And the recording of the land in respect of municipality and Nabachari has been made on the basis of that document. And in paragraph 10, I have mentioned that how the mutation cases have been allowed, given the table melod by Sali Mahanti and him. But my respectful submission is that, keeping in view of this background melod, the Honorable Single Judge, what he did, Honorable Single Judge said, Ajib, I am claiming title in respect of a property. Therefore, since the record of right do not create or extinguish title, I should go to a suit. But the thing is just reverse. But I have the antecedent title. 31 record of right is in my name.
If they have to go to the court, if
they are claiming that they have got settled in the OEA proceeding.
Correct.
So onus lies on them to establish that those record is valid, that order is valid. It exists. The entire record, all these cases are revolving around that order, which is 78 of OEA Act. But if this plot khata doesn't belong to that Tauji itself, doesn't come within the purview of the Tauji which got vested in the state, and 1930 Privy Council decision says how much share the intermediary will get, and on the basis the vesting has taken place. But question doesn't arise that for settlement. The property stood recorded in the name of municipality. 87 also is stood recorded in the name of municipality. 78, they created the document, and on that basis they've sold, and the purchasers are now claiming the right over the property. My honorable respects from Submittal Lordship, the honorable single judge has couldn't approach from the correct angle.
All right.
We have the antecedent title. They are claiming that they have got the property. So they have to establish it. The record of right could not have been corrected when the matters are pending for the Board of Revenue.
All right.
That is plain and simple matter. Both the cases identical.
All right.
Lord,
Your affidavit is there.
Lord, I give it. In fact, and that compilation.
Okay.
In fact, the affidavit and that compilation your lordship will find. Let me clear that cloud with regard to the mutation allowed for 438 decimal. That let me clear that cloud first. The purchase is something less than that, and mutation is allowed 438 decimal. That is factually incorrect. The submission is factually incorrect. My claim of title in respect of 316 decimal, and that is what has been allowed. I can show that mutation order to your lordship. 438 decimal has not been allowed by Tahsildar.
All right.
That is factually incorrect. Kindly see that mutation order. That is available to the counter filed before the honorable single judgment. And I'll only remove those clouds with regard to that OEA proceeding, the submission kindly similar. That is at page 100 of the counter filed 12031 of 2006. Kindly see. That's a repeat before the honorable single judge. And the mutation allowed, if a lordship sees, it is only 316 decimal. I can show this to a lordship if a lordship finds it difficult
No,
to
we
get.
have the repetition here.
Kindly see.
Which is the annexion. Counter is.
Running page 100, your lordship may see from that counter. That is the mutation case number 1479 of 1995. My lord, I can only refer to the page numbers because the annexure number are not getting.
Annexure G by 6.
Annexure
G by 6.
G by 6.
Last annexure.
Last annexure.
97 to 103.
Kindly see. Annexure G by 6. G by, no? G by 6.
G5 is the last one, sir.
Last annexure. Page.
Can I just hand it over to your lordship? So instead, your lordship find it difficult to find out from these bulky records.
We have bookmarked, but
In fact, see the mutation, lord. The municipality is also trying to, lord, submit the facts which is contrary to records.
30th May 96. We have this.
Right. Page 100, and then your lordship see the net area that is allowed. If a lordship kindly see, the net area would be 316 decimal. No? 316 decimal, 276 at page 100. But this is on the basis of my purchase. Thereafter I have purchased it from one Vaishali Mahanti, who is a purchaser, common purchaser from Kumar Acharya, 40 decimal. We claim only this. Am I clear, madam? So it is 316, not 438, as was submitted to the lordship. Now let me clear. But those mutation matters are no more relevant because the settlement matters your lordships are dealing with now. So and that order passed by the mutation authority, I'll just point out the another order passed by the honorable single judge. The matter was carried to this honorable court. If a lordship sees that order, page 72 of my today's affidavit, my lord. Page 72 of my today's affidavit, my lord. It is in fact at page 79, brother. Are your lordships having that? Running page 79 of today's affidavit.
Yes, we have it.
This mutation matter was dealt with by the honorable single judge of this honorable court in this repetition. And this batch of matters, my lord. 20,538 of 2009. The order is passed taking into consideration para 11, Lordship got it.
Yes, taking into consideration.
You are taking into consideration the fact that since final ROR was published 1987, Tahsildar Cuttack could not have entertained the mutation case in 1995. Notification relied upon by the petitioners cannot override the statutory provisions of OSS Act. Thus, the mutation case entertained by Tahsildar Cuttack being without jurisdiction. Any order passed earlier confirming or reversing the same subsequent to that are ineffective. However, since it is submitted at bar that writ appeals are pending before this court against the order passed by the Honorable Single Judge, parties will be governed by the decision of this court in the said writ appeals, as well as orders to be passed in OE revision case number 29 of 2009, stated to be pending before member board of Odisha Cuttack. So the Honorable Single Judge has protected both the ways, saying that this mutation and entire thing will be subject to orders to be passed by your lordship, and that OE revision 29 of 2009 is still pending before the member board of review. Now, my lord, one more cloud I want to clear with regard to non-availability, rather the submission that was made that the OE case never existed, it's a fraudulent action. That was rather submitted for lordship. Lord, I have filed, in fact, I'm sorry, I filed these documents today only for a lordship. Kindly see. The OEA case, I am concerned about Khata number 917 million, which stood settled in favor of my vendor, Navkishore Acharya. Let me just quickly take your lordship the background of the title. This very property, Gajendra Acharya was a family. They were the ex-intermediaries. There was a suit for partition among themselves in the year 1931. That partition suit got disposed of, allotting a particular share in favor of Gajendra Acharya. Now that partition suit, through appeal, was carried to Privy Council. Now 31 Privy Council has a reported judgment. My vendor's share got allotted in his favor pursuant to the judgment passed by the Privy Council. Thereafter, my client's vendor, Navkishore Acharya, son of Gajendra Acharya,
right,
he applied for settlement on section 6 and 7 of the OE Act.
Right.
Now the settlement order, if you
yes,
the settlement order under the OE Act, my lord, kindly see that order of settlement passed under by the OE authority, my lord. That is OE settlement order, my lord, that is 78. Page 33. My lord, page 33 of that affidavit, my lord. Today's affidavit, page 33, 7/1/1978.
Yes.
Lordship sees this certified copy bears the number, date, and entire thing. But this is the order 7/1/78, order of settlement passed in favor of Navkishore Acharya.
The original of this nobody sees.
I'll tell you, Lordship, about that. I'll tell about it. Now, after the settlement order was passed, when dispute emanated between municipality and me, municipality filed an application before the collector to conduct an inquiry that this settlement is fraudulent. It has never been done. Filed an application before the collector. That is OEM case number 4 of 1998. Kindly see that application. That is at page. Your lordship has rightly borne out about. Kindly see at page that application, my lord. The municipality filed that application before the collector. Municipality application. We are at page 32 of this today's affidavit, man.
Page 37.
28. It starts from 28. The prayer is at page
32.
Right. 31, 32. 30. It is therefore prayed. The application is, the entire application I filed before the collector starts from page 28, Miss case number 4 of 1998.
Yes.
Lordship may kindly look at the prayer. It is therefore prayed that this honorable court may be pleased to issue notice to the opposite party and after calling for impugned records, make an inquiry regarding genuineness of the OEA settlement order passed in OEA case number 3699 of 76. Lord, pursuant to this prayer, this record was called for. Now, your lordship may kindly see one letter. I'll just show your lordship one letter from Tahsildar, my lord, page 17. Kindly see. Page 17.
Yes.
Page 17 is the letter of Tahsildar
Yes.
to the revenue officer inviting a reference to the letter cited above. I am to say that Collector Cuttack in his order dated so-and-so has been pleased to call for OA case number so-and-so in connection with above miss case number 4 of 98 and to file objection if any on the date fixed in this connection. It is stated that OA case number 3699 of 76 has already been sent to ADM OLR by this office letter number so-and-so dated 4/4/85 as required by his letter dated 14/2/85. The copy of the letters are enclosed herewith for ready reference and the said OA case record has not yet been received back from the ADM Cuttack, as a result of which Tahsildar is unable to file objection. Now your lordship may see Tahsildar's letter, it was submitted to the revenue officer. Kindly see page 15, ma'am. Kindly see page 15.
Yes.
Page 15. It is by this letter, Tahsildar submits the record to ADM, my lord. Kindly see. These letters are not, they are all official records, my lord. Page 15.
No, but has anyone seen the original of this letter?
Beg pardon?
Has anyone seen the original of this letter?
I could not.
No, has anyone seen the original of this letter?
Yes, my lord. These are all. Lord, can't be. These are not disputed. These are not disputed, my lord. This is the letter from Tahsildar submitting record to ADM, my lord. Kindly see that page 15, ma'am. With reference to your letter cited above. On the subject, I am to submit here with the statement of facts indicating their irregularities there as follows. It is for the purpose of filing a review. This record was submitted to the ADM. Kindly see, my lord. The OA case record 3699 of 76 has been started on section 6 and 7 of the OA Act for settlement of land in Mauja, Bahar, Vishnava for plot number so-and-so, Khata number 917, which I am claiming, my lord, for an area of 946 decimal. But it appears from the report of RI that the applicant was lessee in respect of the Suitland and was paying rent as the proprietor. In 1932 settlement ROR, Suitland stands recorded in the name of Cuttack municipality as status Anabadi, and classification of the Suitland is Puratan Patita. During document regarding possession, change of roof and assessment of holding tax has not been examined. The lease deed dated 12 so-and-so and the lessor's authority leased out the Suitland has not been examined. Permission from municipality obtained in the year 1964 have not been examined. OA case number is also enclosed. Kindly similar. OA case number is also enclosed for taking necessary action at your end. Now, my lord, this to the ADM, it was submitted for the purpose of filing a review application. Then kindly see, my lord, page 14, just the previous page, man. Now, kindly see, my lord, the inquiry report. They have conducted a full-fledged inquiry about this record, page 12, my lord. Then I'll take your lordship to the collector's order. What happened to that miss case 4 of 98? Kindly see page 12. This is internal page 4, B. Lordship got it?
Yes, please.
The then bench clerk, Sri Vaishnav Charan Parida, admits to have received the disputed OA case record along with letter number 4485 from the Tahsildar Sadar Cuttack in Tahsil Office Peon Book. He has claimed to have sent the case record to Revenue Section 23/485 without mentioning any date diary entry if maintained by him, and the reasons for keeping the case record with him till 23/485. An administrative inquiry may be initiated in this regard to find out the mischief and commission of fraud. In view of the above, it is not possible to produce the disputed OA case records also. But here, the district revenue officer conducts an inquiry and writes that this particular officer or clerk has received the record. Now it went missing from either ADM's office or OLR's office. My lord, they have conducted an inquiry on this. And also, your lordship may kindly see page 11, my lord. The said disputed OA case record bearing 3699 of 76 received by Sri Vaishnav Charan Parida, junior clerk, the then bench clerk to ADM Cuttack, claimed to have sent the revenue section received by revenue section 23/485 need further probe in the following points. Now the prove again, there was also another inquiry, man. Page 7. Kindly see page 7.
Yes.
Sri Vaishnav Charan Parida, para 6. Vaishnav Charan Parida in his written reply dated 25/12/2000 admitted that he has received the case record from the Tahsil office and has taken the plea that it was sent to Revenue Section 23/485. The explanation is not found satisfactory with regard to sending of case record to OLR section. His plea that one Tilochan Ratha, the then steno to ADM, have some knowledge about the case doesn't hold.
Might
The then steno to ADM, sorry, might have some knowledge about the case record doesn't hold good. After the plea that he sent the case record to OLR section 23,485. On 26/2000, Sri Parida again in his application requested to allow him 15 days time to search out the missing record bearing OA case number 3699 of 1976. Till yet, Sri Parida has failed to produce the case record. He has failed to submit the satisfactory explanation, whereabouts of the case record after he received the same from Tahsildar Sadar Cuttack. So, my lord, what I am trying to persuade your lordship is it is not that it is completely non-existing record. It is not a case that it was never existed and some kind of fraud created by virtue of non-existing record. Record has gone missing. That's the admitted position. And there are records to that effect. Of course, it has to be. Then your lordship may see that in para 8 and 9, my lord, of this very document. Now, therefore, either detailed inquiry, I come to conclusion that plea of sending the OA case record to OLR section from that ADM section to OLR section is disbelieved in this inquiry. But in my humble opinion, the submission that was as if ever never existed and out of air it was created and fraud has been committed, that's not. Particularly if lordship sees collector's order again.
Para 9, it's suggested for reconstruction.
In para 9 at page 8, further it may be directed to reconstruct the case record. Kindly see, my lord.
Yes.
Para 9. Further, it may be directed to reconstruct the case record, and Tahsildar Sadar Cuttack may be directed to submit history sheet and the present position of the lands involved in the OA case number so as to take legal action to set right the fraud committed in the said case. Now, my lord, kindly see the order passed by collector on this in this revenue miscase itself. The collector,
18.
Page 18, my lord. And this collector's order, they have never challenged. It has been allowed to attend finality, my lord. Page 26, the relevant portion. In reply to the issue, Lord, this is on their application to hold an inquiry, Lord, as I have shown to your lordship, Lord. Revenue case number 4 of 98. On municipality's application to hold an inquiry. In reply to the issue, it may be stated that certified copy of a case is issued under the provisions of Odisha Record Manual. As such, in absence of the original case record, the authenticity of certified copy of the order cannot be disbelieved and hence authentic until contrary is proved in proper court of law. The factual details are submitted by the writ petition or reveals that Suitland was settled on section 6 and 7 of the OA Act in favor of vendor of opposite party number 3 and 4, means we. And order of settlement under OA Act is an enabling order for creation of title in favor of vendor of OP number 3 and 4, which cannot be interfered with by any authority under the provisions of Odisha Survey Settlement Act 1958. Any wrong order passed by OA Act is subject to modification under the provisions of the said Act only. And in this regard, it appears that petitioner CMC has failed to agitate its grievances, if any, in any appropriate court of law under provisions of OA Act. Instead, it has preferred wrong proceeding in an appropriate court, in an inappropriate court for redressal of its grievances. As this court is not competent to adjudicate the matter relating to allegation of fraud, it is not competent to entertain revision proceeding against order passed in mutation appeal. In view of the foregoing reasons, this court has no other option but to drop revenue case number so and so. This order has not maintainable. This order they have never challenged, madam. And again, I'll take your lordship now.
Issue number B.
But issue number B, your lordship will find with regard to non-availability of the record, whatever is submitted now at page 25. Madam.
Yes.
Kindly listen. Page 25 of that very affidavit. It's an admitted position of law that allegation of fraud is within competence of civil court. That any allegation of fraud can not be raised in a miscase before the collector, which can at best be of an administrative nature and as such has no legal tenability. Further, any allegation of fraud is to be dealt in the line a criminal proceeding before the onus lies on the complainant to prove it with cogent evidence. In the instant case, non-issue of certified copy to the petitioner CMC due to non-traceability of original record in OA case number 3699 of 1975 may not by ipso facto prove the fraud. The limitation of 3 years as provided on section 58 of the Limitation Act for case of fraud and filing before an appropriate court has not been followed in this case. Conduct of the petitioner CMC involving itself in litigation contesting the said issue in different courts of settlement and mutation administration proves that it was within knowledge of the petitioner CMC about the same order passed in OA case number 3699 of 76. which has not been assailed in proper court of law as provided under Section 58 of the Limitation Act, traversing through the date chart submitted by the learned counsel for the writ petitioner between period from 31/8/1963 to 13th of August 1987 proves that in spite of Sabiq ROR 1931, Hall Settlement ROR 1987, due care has not been taken by the petitioner CMC in proving the case of fraud in proper court of law. Hence, the issue is answered against in negative. Now, your Lordship may see.
Before ADM appeal.
This order was appealed before the ADM, my lord. That is at page 45. Lord, they preferred an appeal, page 45. And this has been also dismissed. Dismissal order.
4 of 2006.
Yes, my lord. 4 of 2006. Now, your Lordship may see page 50, my lord, of this very affidavit. I'm sorry, I'm dragging your Lordship from page to page, my lord.
Oh, that's okay. Yes.
Page 50, my lord, this is the revision petition 29 of 2009, filed before the Board of Revenue, challenging that very 78 order. Now, pending adjudication of this revision under the Statutory Act 38B of the OEA Act, now submissions are made against that very order before your Lordship, my lord, which will definitely have an effect of prejudging the entire proceeding filed before the statutory authority under the Statute OEA Act, my lord. So, arguing on very maintainability of the order, validity of the order, sustainability of the order, they are already in revision. Now, second question, my lord. Let me take your Lordship to my claim of title. Lord, as I am trying to project your Lordship is, I am a bona fide purchaser for consideration on the basis of OEA settlement order from Navkishore Acharya. Now, what is my claim of title? Kindly similar, I have 4 sale deeds under which I have purchased 316 decimal. Now, my sale deeds, my lord, if your Lordship sees, annexure G by 1 to that counter, my lord.
Yes.
G by 4, my lord, to that counter.
Right.
Lord, this is annexure G by 4. G by 1 to G by 4. All these are my 4 sale deeds. And on the basis of a compromise decree in a suit from Boishali Mahanti. These are all my claim of title. And again, Lord, on the basis of these sale deeds, Lord, Cuttack Development Authority has approved my building plan. Today, I have a residential house there. I am residing with my family. Lord, if your Lordship passes from that Badambadi Square towards Badambadi bus stand, at the right side of that area, Lord, this particular building is there. It's a residential building of mine. I have purchased it. Municipal, Lord, there are documents I have filed today to show your Lordship, Lord. The holding tax receipt. Municipality has been issuing me holding tax receipt, accepting holding tax from me. Kindly see the documents, Lord. That is at page 92 of today's affidavit. This is my building plan, approval of my building plan in the year 1995, page 92, by Cuttack Development Authority. And my purchase is on the basis of permission granted by Urban Land Sealing Authority. That is at page 81, my lord. And all these permissions, Lord, have never been challenged by municipality anywhere. Kindly see page 81. The Urban Land Sealing Authority granted permission for sale of this property. Page 81. Yes. Now, your Lordship may kindly see there are series of permissions, page 81 and 82. Then your Lordship may kindly see the approved building plan at page 85 of 1990. Then one more approval is page 92, my lord. Then Lordship see page 99 is the holding tax receipt issued by the municipality itself in my favor. Page 99. Now, what is today the litigation? Your Lordship got page 99. Yes, yes. Now, but today, what is the litigation before your Lordship? Before your Lordship, the scope of the litigation is challenging the order passed by the Survey Settlement Revisional Authority. Whether the land will be recorded in my name or in the name of the municipality. That is short litigation before your Lordship. Now, under the limited power in a summary proceeding on section 15B, the Commissioner has passed an order to record it in my name on the basis of these antecedent titles which I have shown to your Lordship. Now, that order challenged before the Honorable Single Judge. What the Honorable Single Judge has said, kindly see that order, the judgment. The Honorable Single Judge has not done anything, my lord. Only kindly see that judgment passed by the Honorable Single Judge, para 13 onwards. Page 94 of writ appeal 467 of 2010.
Yes.
The Honorable Single Judge, para 13 onwards, has dealt with the matter, and at para 15, kindly see, in the case at hand, municipality claims title over the property on the basis of ROR prepared by the Settlement Authority India 1931. The Joint Commissioner Settlement and Consultation attack, however, by the impugned order has directed to prepare ROR in the name of OP number 2. A ROR is prepared under Survey Settlement Act. It is no more a syndigra by virtue of a recording made in the ROR. Neither title is created nor the same is extinguished. So and so judgments are cited. A person claiming title can establish the same in proper court of law. It is also well settled that the settlement authorities have no jurisdiction or authority to decide disputed question of title. In view of the aforesaid clear position, while not interfering with the impugned order, which neither creates nor extinguishes title, this court disposes of both the writ petition with an observation that orders passed by the Joint Commissioner Settlement and Consultation would be subject to any decision made in the question of title of the land. In other words, if the title is decided in favor of petitioner by the competent civil court, the ROR shall be corrected accordingly. My lord, as submitted to your lordship, the Honorable Single Judge has never said the municipality to go in appeal. It is not correct. Kindly see, my lord, it has only left the option open. Anyone can approach the civil court on this, and there are judgments to that effect. I can cite 2007 Supreme Court, my lord. Kindly see, my lord. It is only 2007 Supreme Court I have given to your lordship, my lord, along with the note of citation.
Right.
My lord, just see one small paragraph, my lord. Para 9 of this judgment, my lord. Dekho chief.
Yes.
Your lordship, this is 2000, of course, it's a reporting from Supreme today, my learned friend has got it. Supreme today.
76 SEC.
2007 6 SEC 186 para 9.
Right.
This is an additional reason. There is an additional reason as to why we need not interfere with that order under Article 136 of the Constitution. It is well settled that an inquiry in revenue record, an entry in the revenue records doesn't confer title on a person whose name appears on record of right. It is settled law that entries in the revenue records or Jamabandi have only fiscal purpose, that is payment of land revenue, and no ownership is conferred on the basis of such entries. So far as title to the property is concerned, it can only be decided by a competent civil court, so and so year 94 Supreme Court 1653. As already noted earlier, civil proceeding in regard to genuineness of will are pending with the High Court of Delhi. In these circumstances, we see no reason to interfere with the order passed by the High Court in this writ petition. But here in this matter, it was pending in the Civil Court Delhi. Here in this our case, it is pending before the Member Board of Revenue in the shape of OA revision. So the Honorable Supreme Court in clear words has said that no title is decided in the service settlement proceeding, and your lordship is deciding only a dispute arising out of service settlement proceeding. And Honorable Single Judge has not said any party to go to a civil suit. It has only kept the option open, noting the fact that it is neither creates title nor extinguishes the same. And I have also cited some more judgments in the regard, Milo. But OEA order, if subject to if a lordship comes to agree with me that there was existence of record and it got missed, somehow or other it got missed. Subject to if a lordship agree with me, then the judgment, my lord, I have given that judgment. 2014 2 OLR 649. Page 9 para 8, my lord. OEA authority's order creates a fresh title. Para 8.
Yes.
Running page 9 of that note of citation.
Yes.
Citation filed by the respondent.
Yes.
It may be permitted to
in view of such position.
Right, Lord. In view of such position, we are of the considered opinion that observation direction issued by the landed single judge cannot be interfered with until the order passed by the OEA collector come Tahsildar Sadar Cuttack on section 8.1 of it's a case of 8.1 is modified, clarified, set aside by the competent forum. It is stated that in exercise of power on section 38 of the OEA Act, matter has already been heard by the competent OEA authority and judgment is yet to be pronounced. Therefore, Any recording made by Tahsildar Sadar Cuttack pursuant to the order passed on section 15B of the OA Act shall be subject to the outcome of the order passed by the Revisional Authority on section 38 of the OA Act. And at this stage, we are not inclined to interfere with the order passed by the land single judge. However, any recording, correction, or by Tahsildar Sadar Cuttack in compliance with the order passed in the OA revision case 15B of the OA Act would abide by the result of the order passed on section 38 of the OA Act. Now, but the other one is volume 81, 1996, LT 292.
No, if it's the same thing, there's no
Same
need to-
line.
Yes.
I did not duplicate the
Correct,
judgment.
correct, correct.
Lord, one more submission.
Yes.
Lord, going by extreme. Of course, this is an alternate submission of mine. Going by extreme.
In the event.
I trust that this convenience compilation has not caused inconvenience to my lords.
Certainly not. Certainly.
Right. Now, my extreme submission before lordship would be, my lord, assuming for a moment but not accepting that my sale is void ab initio. I mean, my purchase is void ab initio. If a person goes to a civil suit, I mean, either of the parties are relegated to civil suit, I will definitely have a ground there to take a plea of adverse possession there, because by virtue of an invalid purchase, a person is allowed to take a plea of adverse possession, well settled position of landlord. There are judgments I can give to a lordship. If a person claims a title on the basis of either a ostensible purchase or by an invalid purchase, he has the option to claim adverse possession of the property subject to 12 years period of limitation. If the
But that would be subject to what you plead, what you adduce.
Correct, correct, sir. Only before a civil court. But your lordship, I only intend to say that let the doors not be closed here, because my residential house, I'm staying there, I'm holding my office there. Let it not be closed here, Lord.
78 it's immediately produced before this objection, settlement objection in either 83, that within the knowledge of settlement.
Lord, my lord friend says me to say, your lordship, Lord. Lord, page 104 of that affidavit, this order, this objection order, this
settlement order,
this
78.
What is this order?
Settlement objection, 78 order produced municipality knowledge before missing of that record.
Lord, this order was produced before the municipality, before missing of that record. This order was produced before the municipality, before the settlement officer, and municipality had knowledge about that. In the objection case, we had produced that order. Yeah, good. That's great.
Can I say something, Brandon?
Yes, yes, please.
Sir.
But in fact, section 55 of TP Act says, if I want to purchase a property, I must examine the title of my vendor.
Correct.
But in the instant case, if your lordship looks at, the khata itself is not an intermediary khata. It doesn't belong to the Tauzi, on the basis of which that 1930 Privy Council decision was there. 30 Privy Council decision relates to the Tauzi, consisting of 3 khatas. The forefathers of the person concerned, he got a share out of it. So 917 khata was never the subject matter there. But question of vesting doesn't arise.
So
If it have vested and resettled fresh title, those decisions have been cited by my friend. A new title is created after vesting. But supposing a non-existent property, which do not exist at all so far as the OEA proceeding is concerned, but question of vesting title doesn't arise. So from very inception itself, if the source of title is not there,
then
you cannot claim all subsequent records that has been done. But inquiry has been conducted, found no record is available. That is exactly I wanted to show. He said, it is not within my domain to declare it to be fraudulent. He said, appropriate court of law can decide it to be fraudulent, but record is not available. But those letters that were cited was never referred to in that order itself.
That's what, if it is asking
Yes.
him.
Those 2 letters are obtained 2001. 85 correspondence obtained in 2001 never relied upon. Now for the first time it's coming here. And he says, I sent it. He said, no, we have not received it. Fact remains, no record is available. Even when my friend was searching, he also directed to get the record. He said, no record is available. So at no stage, from the very beginning till end today, no record is available. Reason being, it is not vested. This khata is never vested. The order is set is from the root of it, from the inception is a nullity. Second part is, if your lordship looks at, but therefore all these documents referred to and orders referred to do not have any bearing with regard to the antecedent title, which never existed. The second limb part that was argued regarding adverse possession, with due respect, I would like to submit, my lord. If I have a title I have sold, it's a defective sale or defective title, adverse possession arises, provided I had title. If Nava Acharya did not have the title, question of adverse possession doesn't arise. You cannot have adverse possession against state. You can't have adverse possession against the municipality. Municipality never sold it. So that principle also not applicable. And regarding this settlement, he said that not to be interfered with is subject to declaration of title. So kindly look at page 96 of the writ appeal. Paragraph 15.
Yes.
The sentence starts, in the case at hand. Well, I got it.
Yes.
In the case at hand, municipality claims title over the property on the basis of record of right. Well, that is exactly my point. It's recorded in the name of municipality and recording is on the basis of the title. So I'm not claiming it is already there. Now they say they have got it by purchase. They must show the person who sold had title to the property. The basis of title is the 1978 settlement. This khata did not vest. It's not the intermediate right. The question of Nava getting it settled in his name doesn't arise.
All right.
Therefore, court could not have thrown me for the last sentence. A person claiming title can establish.
See, throwing you to the civil court.
I am to go to file a suit.
Basically, he's saying, okay, if you do not want to go, I'll now go.
Therefore, the finding itself is all these things are placed. Court should have given a finding, but did not arrive at a conclusion whether it is valid or invalid, all that. And that OEA revision we have filed, the main ground is non-existent proceeding. Now they filed a writ and stayed it. You will call for that record and examine it.
What happens to the Board of Revenue with what is pending there?
So that has been stayed.
By the writ?
By the Honorable High Court. That writ order, writ application may be called for in this case, madam. That is WPC 3697. I'm sorry. It is 10687 of 2016. They have also filed 3 other writ applications. WPC 3697 2021, WPC 2803 of 2018, and WPC 8031 of 2019.
They meaning the same.
They have filed
the same respondents here.
So they have one relates to.
They are all different.
No, is it
permission and all that?
They are all relating to permission.
No, is it the same Govinda Patnaik and?
Yes, yes, yes.
Can I just explain in a minute? Can I just explain it? About that petition 3697, 3697.
That's a matter. Originally municipality had filed that revision, OA revision. Now pending adjudication of the OA revision, what they did, the collector, which is the adjudicating authority, OAM is case number 4 of 98, which I have shown to your lordship. They wanted to transpose collector as a petitioner there. So we challenged that. So in any view of the matter, that stay can be vacated. There's no problem in that. Matter parties can be relegated to that proceeding. I don't mind, or lordship can call it for and vacate the stay order. My second submission is kindly see para 13 of the learned single just separate.
Yes.
Para 13, page 94. I'll just small submission, but I'll conclude it by showing this only paragraph. Para 13.
Yes.
Heard the learned counsel for the petitioner, learned counsel for the opposite partner too, and perused all documents and orders meticulously, accepting that the lands were recorded in the name of municipality in the year 1931 during settlement operation. No document has been produced to establish as to how municipality acquired title over the lands. On the other hand, the endeavor of the Cuttack municipality, as long as that the opposite partner too has not acquired any title over the lands, but then in view of the clear position that settlement records neither create nor extinguish title, and as the title of the extended was virtually settled by civil court and in the Privy Council, it can be safely concluded that Cuttack Municipal Corporation cannot assail the same. Admittedly, out of the self-same area of 606 decimal, which was settled in favor of Navkishore Acharya, the extended under OA Act has executed more than one sale deed in favor of outsiders, more than one sale deed in favor of the outsiders. No steps appears to have been taken by Cuttack Municipal Corporation to claim right over the said property. They have selected me only, others are left aside. At the other hand, Cuttack Municipal Corporation had accepted their right title and interest. Thus, it is not open to Cuttack Municipal Corporation to assail the title of opinion number 2 alone. Further, the municipality is stopped from doing so in view of the past conduct. So these are all disputed. So these are all disputed questions of fact. Now, question of claim of title, rival claims of the parties. And so far as 55 of Prospera Property Act, we have inquired into. We have, on the basis of the OA order only, we have purchased it. If at all you are challenging it, it's only a civil court. And fraud particularly cannot be asserted in a jurisdiction. Blood lordship knows it, well-established position. Parties have to be relegated to a civil court for that. Order 6 comes into operation. The fraud is to be specifically pleaded, proved. Order 6 of CPC.
Right.
So that Vrindavan Sarma case, your lordship knows that Vrindavan Sarma case. But Supreme Court has held it's fraud. If it is prima facie fraud, question of inquiry into fraud doesn't arise. It's a prima facie fraud on the face of it.
It is Vrindavan Sarma is overruled by. Vrindavan Sarma is overruled in Joginder Singh ji case. I'll cite that judgment 2015 Supreme Court by the Honorable Supreme Court as Lordship Nagappan was there. Vrindavan Sarma ratio is overruled. I'll give that judgment. I'll give that judgment. Milord Vrindavan Sarma, Milord, that Andhra Pradesh case, Jagan Mohan, District Collector Rangareddy. District Collector Rangareddy, 2015 Supreme Court, Vrindavan Sarma's ratio is overruled and clarified. Joint Collector Rangareddy versus State of Andhra Pradesh. But this is the judgment. I am grateful my friend has got it. There is. Allegation of fraud was leveled here. Referring to limitation, the Honorable Supreme Court has said Vrindavan Sarma is not the ratio. Sir, it has been distinguished.
Distinguished.
Overruled. Immediately, I'll indicate that specific paragraph and give it to Lordship.
Impliedly distinguished.
Correct. Implied. Yes.
All right. Good.
Grateful.
The question of fraud itself is the very face of it is available. The instant case. When it is there on the face of it, question of inquiry doesn't arise.
You see, the court is informed that the following writ petitions pending before the learned single judge have a bearing on the matter being argued in this court. That is writ petition civil 10687 of 2016, 3697 of 2021, 2803 of 2018, and 8031 of 2019. The records of these writ petitions be requisitioned for the purposes of reference. Then we say in the other writ appeals. Arguments heard, judgments reserved.
Grateful.
Just put down appearance. List is over. After lunch, we'll come.
connected to from arising out of one PS case. And another two cases, one is filed today, another is going to file tomorrow. And it all has to be taken together for convenience. Can it come some other day, either Wednesday or Thursday or after July?
Which are the two cases?
52.
All right.
There are two matters in the 52 with.
All right. At the request of Mr. Mishra, let's look at the roster bench.
Last week of July, Mal.
On 2nd August. All right.
Mal?
2nd August.
Oblige. Not that 44 and 59 may be no instruction.
44 and 59.
59, no instruction.
No instructions.
That your usual order, your lord.
Right.
Oblige.
Right.
Weekly list fresh admission item number 1.
None of dismissed.
Item number 2.
May I please, your lordship?
Yes, please.
Lord, in this case, I am not pressing my prayer to quash the FIR of in this case, my lord, but humbly pray, my lord, let that vigilance case, VGR number 2 of 2014 may be targeted and sealed, because 9 years it is still pending. They are doing nothing in this session case in the vigilance case, my lord. For that, my disciplinary reporting is also hanging. They are neither paying my area
That's
salary.
not the scope of this petition, sir. That's only difficult.
My lord.
That's not the scope of this petition, no?
No,
only for quashing.
I am not pressing now for quashing, my lord. I only pray that vigilance case may be finished, my lord, because 9 years it is sub judice.
Counsel for the petitioner states that while he's not pressing for the quashing of the proceedings at this stage, he would be approaching the government for expeditious disposal of the disciplinary inquiry.
BGR number 2 of 2014 is vigilance case.
That all you can write in your letter, so your number you can write.
Okay.
Recording the above submission, the petition is disposed of. The interim order is vacated.
Item number 3.
So item number 3, no instruction.
No instructions dismissed.
Item number 4.
None appears dismissed.
Item number 5.
None appears dismissed.
Item number 6.
My lord, in item number 6, my lord, challenging the order of cognizance, my lord, under offense 420, 403, 409, 120B and 34, my lord. And the case of in the year of 2014, my lord.
What has happened in the case?
My lord, whole allegation against the
No, there's no
petitioner
years. By now it should be over. There's no interim order here.
There is no stay order.
my lord.
Permitting the petitioner to place all pieces.
Item number 7.
Item 7, may I please, your lordships. My lords, I have challenged the order of cognizance. It's a case under section 354, 341, 323, 506 and 34. My lords, the informer parties were cultivating in their land, and the allegation that due to the cultivation of that land, there was a long civil dispute pending between them. And an counter case has also been filed by the petitioners against the informant, my lords. So my only submission, this is a civil dispute given the color of a criminal proceeding, my lord.
Anyway, so permitting the petitioner to resolve, please, at the appropriate stage. The petition is disposed.
Item number 8.
None appears dismissed.
Item number 9.
May I please, lordship. The person who implicated the present petitioner has already been acquitted by the trial court, my lord. Had annexure 3, my lord. Allegation against this petitioner, my lord, is escorting the car, my lord. The persons who implicated this present petitioner are already acquitted, my lord.
So that you can point out to the trial courts, permitting the petitioner to resolve this at the appropriate stage. Petition is dismissed. Or
Item number 10.
Permitted to raise all points.
of permitting. Right.
Item 11.
None appears dismissed.
Item number 12.
Memo taken on record. Dismiss is withdrawn.
Item number 13.
Let's see, permitted to raise all the points.
Permitting the petition.
Item 14.
None appears dismissed.
Item number 15.
Same order.
Item number 16.
My lord, 16 on behalf of Mr. H.N. Mahapatra, kindly taken up next week, my lord, my seniors.
No, it's all right. permitting the petitioner to raise all fees, the appropriate stage.
At note 17.
Item 17, your lordship's liberty may kindly be granted to
Yeah.
resolve the.
Permitting the petition. Same for the next one also.
My lords, item 18, withdraw.
Withdrawn, dismisses.
Obliged lordship.
Item 19.
My lord, 19, my lord, application rejecting the petition under section 243 CRPC. My lord, permitted to withdraw, my lord.
Permitted.
Item number 20.
Lordship, permitted to withdraw with liberty to file a better application.
No, not at this stage. Permitting the petitioner to raise all fees, the appropriate stage.
Item number 21.
None of these dismissed.
Item number 22.
Item 22, your lordship, I have no instruction regarding the status of the case before trial court, your lordship. Your lordship may be taken up next week. In the meantime, I will take instruction.
No, what's the matter about, sir? This is PC Act.
Yes, your lordship.
And there's no stay.
No, your lordship.
Permitting the petitioner to raise all fees at the appropriate stage.
At note 23.
Please, lordship. Lordship, in this case, the FIR under section 420, 294 and 506. Lordship, in this case, this is amicable settlement between the parties, and affidavit is joint affidavit is filed, lordship. The genuineness of the affidavit also verified by the investigation officer, lordship. Kindly see, lordship, page 21, lordship.
Which is one of the informants. There are several informants, is it?
Lordship.
How many informants are there in this?
Lordship, 2 informants are there.
So only one has filed the affidavit.
Lordship, both the informant are each. Lordship, kindly see page 21.
Not even parties here, sir. You pointed out to the trial court, permitting the petitioner to raise all pleas.
Lordship, already compromised by the Honorable Court, Lordship.
Go to the trial court.
As per direction of the Honorable High Court, Lordship, the genuineness of the affidavit also
the informants
verified.
are not parties here. So nobody can, they are not here to confirm that they have filed the affidavit. Only one of them has filed. There are two
Lordship,
informants.
Lordship, both affidavit are filed, Lordship.
Anyway, you pointed out to the trial
Lordship,
court.
page 21 and page 23, Lordship. Lordship. Lordship, earlier order of the Honorable High Court is page 18, Lordship. Page, Lordship, kindly see page 20, Lordship. Page 20, second para, Lordship. As per the instruction.
Verified.
Lordship.
Affidavit has been filed by both the informants, but is not verified.
Lordship, verified this is. Lordship, page 20, kindly see.
20.
Page 20, third para, Lordship. As per the instruction, Lordship Counsel on behalf of the state submits that he has obtained instruction in this matter. The informant has entered appearance and filed affidavit submitting their matter has been amicable settled between the parties. Lordship.
What instruction has he obtained?
Lordship, in page 18, Lordship. In Annexure 3. Lordship.
On the basis of it, the bail was allowed. The bail granted to the accused. Okay.
See, 18 only says the state will take instructions.
Lordship. Lordship, in Annexure 3, Lordship, page 18, Lordship. The file to
Same bail
affidavit
application. All right. Same bail application. All right. Counsel for the petitioner points out that both informants have given their respective affidavits, stating that the disputes with the petitioner have been settled. He refers to the bail order passed by this court. The orders passed by this court on 7th May 2018 and 18th May 2018 in BLAPL 2616 of 2018, which show that the said affidavits were in fact verified by the investigating officer as to their genuineness. In that view of the matter, they take from the prayer clause and all proceedings consequent that were hereby quashed. On it.
Obliged, Lordship.
Item 24.
My pleasure, lordship, are permitted to raise all the points.
All right, permitting the petitioner to raise all.
Item 25.
Same order, my lord.
All right.
And I pray, my lord, item number 40 and 69.
Same order.
My lord.
All right. 25, 40 and 69.
Item 26.
None appears dismissed.
Item number 27.
I may permitted to agitate all these points before.
All right, permitting the petition. Please.
Item 28.
Okay, may I please, my lord? My lords, the petitioner challenges the annexure 1, that is the cognizance order, my lords, under offences under section 498A and 4 of the DP Act, my lords. As per annexure 3, 13B application has been allowed between the OP number 2 and the present petitioner, my lord. My case is squarely covered under the judgment of the Apex Court in B.S. Joshi versus State of Haryana, my lords. All the consequential proceedings should be.
No, but where is the affidavit?
On that note, lordship, it was notice was issued as per my instruction on the last date, but she did not enter appearance. As per my instructions obtained today, lordship, she has remarried and.
There is a decree of
mutual divorce.
All right. You say annexure 3 is the copy of the decree dated 6/9/2018 passed by the Family Court Cuttack in civil proceeding number 477 of 2017, dissolving the marriage between the petitioner and opposite party number 2 through mutual consent under section 13B of the Hindu Marriage Act 1955. There is no opposition to the prayer in the present petition, although opposite party number 2 has been served. In that view of the matter, take the prayer clause and all proceedings consequent thereto hereby quashed.
Much obliged.
Item 29.
Just pass it over. There's a compromise agreement and he's not turning up. Pass over.
Item 30.
None appears dismissed.
Item 31.
None appears dismissed.
Item 32.
None appears dismissed.
Item 33.
33, my lord, the counter note.
You're there for the petition.
Counter filed, my lord, the.
I have filed a counter affidavit.
My lord, that also, my lord, not received my memo.
Kidnapping and all that, sir. There's no compromise, nothing. Is there a compromise?
No, there is no compromise. We have filed a counter affidavit.
No, there is a compromise affidavit, sir. The informant is given an affidavit. You place this before the trial court, sir. Permitting the petitioner to resolve peaceably.
Item 34.
None appears dismissed.
35.
None appears dismissed.
Item 36.
36 millets. Petitioner the husband millets. And the opposite party the wife millets. And petitioner filed the order of maintenance filed annexure 2 millets. Order of maintenance filed challenging my lord annexure 2 that page 12. The passed by the subjudicial magistrate first Bhubaneswar millet, awarding my lord rupees 4,000 per month millet with millet. Why? Without the expert order of maintenance millet. And my lord, I'm challenging here millet. The petitioner is an army official, army working as army, and my lord
for the informant.
Yes, your lordship. May I please, your lordship? Lordship, this matter has already been disposed of ex parte. The order which he was challenging, that was for quashing of the order during the as against the interim maintenance. Now the matter has already been disposed of.
Oh, I see. Counsel for the opposite party number 2 informs the court that the main matter itself has already been disposed of. In that view of the matter, the present petition has been rendered infructuous. It is disposed of.
Item number 37.
In this case, Lordship, matter has been settled. The affidavit flagged by A, Lordship.
You are appealing for the other side?
For the opposite party, informant, Lordship.
All right. Counsel for the opposite party number 2 confirms that the matter has been settled between the parties. The affidavit to that effect has also been filed by opposite party number 2. In that view of the matter taken on the prayer clause, and all proceedings consequent that are hereby quashed.
38.
Item 38, Your Lordship, no instructions.
No instructions dismissed.
39.
None.
So item 39, could I get the information on the talk of compromise going on, Lordship?
So, all right. So, whenever it happens, you point out the trial court, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Item 41.
May it please your Lordship, I am appearing on behalf of Mr. Sambit Mahan, the counsel for the petitioner, my lords. My lords, the present petitioner have filed this present application on the grounds of quashment on grounds of marriage, my lords. The present petitioner number 1 is the wife and 2 is the husband, my lords. And the FIR was lost by the wife, my lords. Then subsequently they have, after the registration of FIR on.
All right. Both parties have filed their affidavits stating that they have been married to each other of their free will. And they're living peacefully. There is no opposition to the prayer for quashing. Accordingly, take from the prayer clause and all proceedings consequent thereto are hereby quashed.
42.
May the challenging the FIR manner on the ground that initially an FIR was lodged by the opposite party 2 manner, with a charge sheet submitted under section 279, 304A, 180, 181, and 196. On dated 18/1/2018. Thereafter, my lord, the complainant has filed an petition complaint case, my lord, stating that whether reported to the PS or not, he has stated that yes, but no steps taken, my lord. Despite that, my lord, the Lord and Magistrate signed they said complaint petition to register under section 341 120B 302/34 under 156(3), my lord. That is an accident, my lord. Police file charge sheet that is a case accident, my lord. The complainant has received the vehicle and also give statement before the IO that there is an accident, my lord. After 6 months, my lord, I am relying on the decision by Appeals Court Priyanka Srivastava.
Where is the complainant's affidavit?
My lord?
Where is the complainant's affidavit?
Complainant, he has stated, my lord, only verification complaint petition, but in the order sheet, the learned JMFC has stated that he has filed the affidavit.
What?
My lord, the complaint petition filed by the complainant through advocate Kasinath Swai and associate advocate complainant files a wakalatnama in favor of the, which is checked and verified. They have accepted.
No. So the complainant has not withdrawn his complaint or anything.
My lord?
The complainant is not withdrawn his complaint.
No, my lord. No. I am not withdrawal, my lord. He has filed a police case, my lord. Your lordship
permitting the petitioner.
No, my lord. Kindly, my lord. He has filed a case that was registered as a Fatehgad Peace Case 184 of 2017. My lord, the police filed charge sheet under section against us, my lord, under section 279, 304A, 117, 180, my lord. Thereafter, my lord, he has filed a complaint case, my lord.
That's all.
He has to, my lord, he has to file a protest petition if he has dissatisfied with the investigation. He has to file a protest petition, my lord. He has not filed a protest petition. He has filed a press complaint, and he has also stated that he has reported the matter to the police. And as per the 210, my lord, 210 of the CRPC, your lordsman, kind of a glance to the 210.
All this you can point out.
No, my lord, the case is, my lord, covered by my lord Bhadana. The case is not made out, my lord.
Can make
no, my lord, your lordship my lord, your lordship has the last occasion direct the state council to take instruction. My lord, what is the report of the police, my lord? Your lordship may kind of a glance, my lord. My lord, 210, my lord, if a magistrate has the knowledge that there is a police investigation, he has to stop the complaint case and call for a report from the police, my lord. Without, my lord, he is mechanically, your lordship may kind of have glance to this decision when I am relying, my lord. Babu Venkatesh, my lord, and Priyanka Srivastava, my lord. Your lordship may kind of have glance, my lord.
My lord, the FIR was registered under section 279, 304, part A. Thereafter, the complaint was filed for different, on different.
No, same issue.
That same issue, but
same issue, my lord.
is different. Some
Ma'am,
other
after the 2 years, my lord. I am relying on.
That is why the magistrate has.
No, magistrate has.
Whether in that section the case is made.
No. Case subject matter is there is an accident, my lord. The son of the complainant died, my lord. He has received the vehicle. He has also given statement before the police. Police filed charge sheet under section 302, 304A, my lord. But if he is dissatisfied, he has to file a complaint, protest petition, my lord. Without filing a protest petition, after 1 year, my lord, he has filed a complaint case, fresh complaint case, and he has also stated that he has reported the matter before the police, but no steps taken. As per the CRPC 210, my lord, the London magistrate has to call for a report from the police officer. What is the stage of investigation or what is the case, my lord? Without following the procedure, my lord, he has mechanically allowed the 156(3) application and direct the police to register a case under section 302, my lord.
Let's see the order of the magistrate.
My lord. Page 14, annexure 2, my lord.
1.
9/5/2018.
We'll send it back to the magistrate.
Yes, sir.
You see, the case of the petitioner is that originally in FIR, Fatehgarh PS case number 184 of 2017 was lodged, arising out of the very same incident under sections 279 and 304A IPC. A charge sheet was also filed pursuant to the said investigation, and no protest petition was filed by the informant. More than a year late thereafter, a petition under section 156(3) CRPC was filed, now alleging that more serious offences under sections 341, 120B, 302 read with 34 IPC were attracted. The grievance is that overlooking the settled position in law, as explained in Babu Venkateshwar's State of Karnataka, 2022 5 SCC 639, the learned GMFC, Khandapada has passed the impugned order dated 9th May 2018 in ICC 50 of 2018 mechanically, asking the IIC of Fatehgarh PS to register a case by treating the complaint petition as an FIR. Paragraph, indeed, the court notes that in the impugned order, the fact that there is an earlier FIR 184 of 2017 in which a charge sheet has already been filed and no protest petition was filed. There's a closure report, is it?
My lord.
In which a closure report was filed.
My lord, charge sheet was filed.
Charge sheet was filed, right. And no protest petition was filed, asking that a graver offense, that the charge should be filed for a graver offense. Full stop. The JMFC had to necessarily deal with the said issue before proceeding to direct the IIC to simply register the complaint as another FIR. Paragraph for the aforementioned reason, the impugned order dated 9th May 2018 is set aside. And 1CC case number 50 of 2018 is restored to the is directed now to be listed afresh, listed before the JMC Kandapara on 1st May 2023 for the issue to be considered afresh. Full stop. In other words, the magistrate will again examine the complaint of the opposite parties along with the affidavit, and after taking note of the previous development of the case, pass a fresh order in accordance with law. A copy of this order shall be sent to the JMFC Kandapada forthwith. The petition is disposed of in the above terms.
Obliged. Item 43.
None appears dismissed.
Item number 45.
None appears dismissed.
Item number 46.
My lord, liberty.
Permitting the petitioner to raise all, please.
Item number 47.
May I please, Your Lordship? The present petitioner, hassling the very initiation of the proceeding, FIR which has been lodged at the behest of the prosecution, I have annexed the FIR. Your Lordship may kindly see the FIR. From the bare reading of the FIR which has been lodged at the behest of the prosecution, that is the police personnel, there is nothing has been depicted in the FIR against the present petitioner regarding the involvement of the present petitioner in the alleged crime. The matter was taken up, the investigation was set into motion. Your Lordship, first of all, Your Lordship may kindly see page 13, annexure 1. Against two persons, another person is unknown, the FIR has been lost. After due investigation, the investigating agency submitted the charge sheet against the three persons, not against the present petitioner. Somehow or other, my lord, even though after closure of the investigation, while the investigating agency submitted the charge sheet against the three persons, there is nothing on the to substantiate any allegation against the present petitioner. He is anyway involved in the alleged crime. But somehow or other, after closure of the investigation, after submission of the charge sheet on 9/7/2016, while there is no allegation, no charge sheet has been submitted against the present petitioner, but it is utter surprise that the investigating agency raided the residential house of the present petitioner along with the Uttar Pradesh police several times and threatened the present petitioner. My humble submission before Your Lordship, it can be borne out from the FIR. There is no allegation against the present petitioner, nothing else. You have submitted the charge sheet against the three persons, not against the present petitioner. For that reason, my lord, my anxiety and my lord, in order to prevent the high-handedness action of the investigating agency.
No, what is this initiation of proceeding in Sonpur? You're not named in that.
No, not named. No, neither the charge sheet has been submitted.
Yeah, then why do you want its quashing?
My lord.
But why do you want the quashing then?
That is for that reason, my lord, I am praying for quashing of the entire proceeding, my lord.
Why? You're not involved?
No way involved.
Then why should
to
you
that extent, Your Lordship may kindly dispose of matter by matter?
He is not an accused. He is not included as one of the accused.
I don't know what he's
saying to quash the charge sheet.
I don't know. It's very strange.
That is the act of the investigating agency. I have submitted before Your Lordship. Because after closure of the investigation, after submission of the charge sheet, with the help of the Uttar Pradesh police, they have raided my residential house.
You should have filed a different petition for that. You can't ask for a quash.
Case or for any other.
Can I pray before Your Lordship? Observing the submission of the State Council, Your Lordship may kindly dispose of this application.
My submission is that you have no locus standi to file this case.
No.
You have no locus standi
because I have not charge sheeted, no allegation is there. Your Lordship may kindly dispose of. Recording the statement of the State Council.
Points out that the petitioner is not named in the FIR, nor is any charge sheet in the, and nor does the charge sheet in the FIR
My lord.
name him. Full stop. In that view of the matter, if the petitioner has any grievance about the conduct of the police, it will be open to the petitioner to seek other appropriate remedies in accordance with law. The petition is disposed of.
48.
Disposed of, my lord.
Yes.
Oblige, your lordship. Oblige.
In this case, my lord, petitioner is a registered owner of a minibus, my lord. He has filed this CRLMC challenging the order of the Lord and ADJ, where the petitioner has not implemented the registered owner as a party and same was disposed of, my lord, directing to release the vehicle. Initially, my lord, petitioner filed this case before the SDGM for release of vehicle. And he has made an agreement with the opposite party number 2, subject to condition that he has paid 70,000 and rest 2 lakhs will be paid 10 equal installment, my lord. During the pendency of this case, police seized the vehicle of the petitioner and petitioner pray before for release of the vehicle. And SDGM rejected his application on the ground that his engine number is not trace out. Thereafter, my lord, the opposite party, which not a he has filed this revision before the additional session judge, and he has pray before the Lord and ADJ challenging this order, my lord. Earlier, he has not a party in this case, and the Lord and ADJ released the vehicle in favor of the opposite party number 2, my lord.
No, you should establish that you are entitled to possession.
My lord, I am a registered owner. I have made an agreement with the.
No, you're not a registered owner. In fact, the details given by you does not match.
My lord,
chassis number doesn't match.
That is correct, my lord.
But seized bus has no engine number, so there's a problem, sir. You're not able to establish that you're the owner.
That is correct, my lord. But
why would they?
In the other hand, my lord, who purchased my vehicle, he had filed an application and he.
That we don't know.
My lord.
Yes.
My lord, I may be permitted to raise this issue before the appropriate forum, my lord.
What issue, sir?
My lord, my payment was not made. My payment was not made.
There is no ground made out for interference with the order dated 28/10/2016, passed by the
till pending.
Learned Additional Sessions Judge Padampur, dismissing criminal revision case number 3 of 2016, whereby the order of the JMFC in Miss case number 56 of 2016, declining the order dated 26 September 2016, passed by the JMFC Sohela, declining to release the seized vehicle in favor of the present petitioner, was affirmed. Paragraph. Counsel for the petitioner claims that the petitioner was the owner of the vehicle. Having purchased it from one Bharat Sahu for a consideration of rupees 2.7 lakhs by executing an agreement. Somehow the papers produced before the court did not substantiate the plea of the petitioner. Just take this off. Just say the petitioner challenges an order dated 28/10/2016 passed by the Additional Sessions Court, Padampur. Whereby the criminal revision petition, sorry, whereby the miss case number 61 of 2016 whereby the criminal revision number 3 of 2016 filed by the opposite party number 2 was allowed, and an order dated 26 September 2016 passed by the JMFC Sohela in this case number 56 of 2016 declining to release a Tata 407 OM bus in favor of respondent number 2 was satisfied. Accepting the plea of opposite party number 2 that he had purchased the vehicle in question from the present petitioner, the additional sessions judge directed its release in favor of opposite party number 2 on his executing an indemnity bond with conditions. Full stop. The grievance of the present petitioner is that the opposite party number 2 only paid rupees 70,000 and did not pay him the balance amount. And therefore, the vehicle ought not to be released in his favor. Full stop. Fact remains that the petitioner did sign all the papers for effecting the transfer of the ownership of the vehicle in favor of opposite party number 2. Full stop. If he had any other grievance about non-payment of the full consideration, it would be open to the petitioner to seek other appropriate remedies in accordance with law. The court does not find any ground made out for interference with the impugned order of the learned ASJ. With the above observations, the petition is dismissed.
Item 49.
Made PG Lordship, liberty may be granted to raise all the views
All
of
right.
appropriate
For
format.
the petition.
Next item also same.
50, same.
Item 51.
My lord, item 51 permitted to withdraw, my lord. 144 surplus to proceeding, my lord. Permitted to withdraw.
Dismiss this withdrawal.
Item 53.
May I please your lordship? I'm through virtual mode, your lordship.
Yes, please. Yes.
This is challenging the order taking cognizance. I have one more stage to raise this point, that is at the stage of charge. May I pray, my lord, I may be permitted to raise this point at the stage of charge because I can raise it at this charge.
Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Deeply obliged.
54.
May I pray for withdrawal? Dismiss this withdrawal. All right.
Item 55.
My lords, item 55, no instructions with liberty, my lords.
There are no instructions request of liberty, sir. No instructions dismissed.
Item number 56.
56 is covered by that order judgment, my lord, that the impugned order has been quashed in this. Last week one.
This is another set, is it?
Yes.
All right. In view of the order passed by this court on 23rd March 2017 in criminal revision number 886 of 2016. whereby the same impugned order dated 25th July 2016 and 8th August 2016 of the SDJ in Puri, is it?
Yes, ma'am.
Has been quashed. The present petition is also disposed of in the same terms by quashing the impugned orders dated 25th July and 5th August 2016. Same.
Item 57.
57, man, kindly take note next week, man. I am for the OP number 2, Lordship. Here the petitioner is the son and the opposite party number 2 is the mother. The son, the petitioner got the appointment on the ground of compassionate appointment. Order was passed in the year 2016 before the law court below, awarding maintenance rupees 5,000 per month. And the same was challenged before the revisional court. And the law revisional court has confirming the judgment passed by the lower court and also imposed the cost of rupees 1,000 to the petitioner.
What's the maintenance amount?
Maintenance 5,000. By that time, the petitioner was got rupees 32,000 per month salary. Now that has been double.
All right. The challenge in the present petition is to an order dated 14 September 2018 passed by the Additional Sessions Judge Chhatrapur dismissing criminal division case number 7 of 2016 filed by the present petitioner, challenging an order dated 28 May 2016 passed by the JMFC Kodala, Ganjam, in MC number 52 of 2013, filed by the respondent, number 2. That is his mother under section 125 CRPC, and directing the present petitioner to pay her interim maintenance of rupees 5,000 per month. Paragraph, counsel appearing for respondent 2, opposite party number 2 informs the court that while at the time of the impugned orders, the petitioner was drawing a salary of approximately 32,000
Lordship
per month.
Lordship.
The said salary is now doubled. What is he working as?
Working as in Coal India, Lordship, as a wagon loader, Lordship.
As a
wagon loader. Wagon loader, Lordship.
Oh. Opposite party number 2 is apparently working in Coal India Limited as a wagon loader. Paragraph. Keeping in view of the above circumstances, the court does not find any good ground to interfere with the impugned orders. The petition is accordingly dismissed.
58.
Lordship, one more, Lordship, I may take appropriate steps before the law court will for enhancement of the maintenance.
That is all. You see, this order does not prevent the opposite party number 2 from seeking enhancement of maintenance in accordance with law.
58.
58, my lord, for quashing of affair on the ground of compromise. My friend is appearing and file affidavit, my lord.
All right. Counsel appearing for opposite party number 2 confirms that the disputes have been settled between the parties. The affidavit is there.
Yes, my lord, affidavit is filed.
Where is that? Yeah, the affidavit of party number 2 is also on record. That means the matter taken to prayer clause, not proceedings consequent that to hereby quashed.
Obliged.
From 59.
59 may. Here, my lord, a quasi-judicial authority passed an order. The petitioner was now he is working as joint secretary, my health. He was working as, my lord, Tahsildar Cutter. He issued some, my lord, legal aid certificate. That was, my lord, alleged to have been, but some by giving some false document, that was issued. When after this, immediately the complaint was received by him, he immediately cancelled that and cancelled that, my lord. Now, the parties are in litigation before the lower court with regard to a suit, has filed a long complaint in Orissa, and no offence is made out against the present petitioner. Here, my lord, that Priyanka Srivastava case will come into play, my lord. where, my lord, they have prayed in the complaint petition itself, you send it to 156.3. The complainant before the court below, he doesn't have the right to choose whether the magistrate will inquire or it will be sent to my lord, police. It is the prerogative of the magistrate to say that, my lord, whether he wants to inquire himself or he wants to send it to the police. Now, under these circumstances, I have challenged the, my lord, the very initiation of the order of the magistrate, sending it to the police for registration of affair, where, my lord, the Priyanka Srivastav's case squarely covers the ground, my lord, where they proceed. May I read that portion of the order? The Priyanka Srivastav.
Who is appearing for?
He was appearing. He said no. Your lordship remembers Mr. Himanshu Mishra, my senior counsel, was appearing for the informant. He in the first hour said that he had no instruction.
Mr. H.S. Mishra was earlier appearing for opposite party number 2. Today, he informed the court that he has no instructions. Fresh notice be issued to opposite party number 2, returnable for the roster bench on 12th May. No, 11th May. 11th, sorry.
Item number 60.
Number 60 minutes, no instructions, liberty to cause election survives.
Or permitting the no, if you say no instructions, no instructions. Just say no, dismissed, no instructions.
61.
None appears to succeed.
Item number 62.
None appears to succeed.
I am for the OP. None appears.
All right. None appears to the petitioner.
Item 63.
May I please your lordship? Matter already settled and affidavit already filed before your lordship, my lord. Opposite party number 2 already entered into appearance and already affidavit filed.
All right. The affidavit of opposite party number 2 confirming that the disputes have been settled between the parties.
I may be permitted to appear to VC Miller.
Yes, please.
Here in this case, I am appearing for the informant OP number 2 Miller, and the matter has already been settled in the case.
Right. Opposite party number 2 also confirms this. In that view of the matter, take from the prayer clause, and all proceedings consequent thereto hereby
Obliged. 64.
Lordship, I am appearing on behalf of the opposite party number 2, madam. 64.
All right. None appears to the petition.
No, Lordship, I am here, Lordship.
Then
In fact,
affidavit is filed.
Lordship, affidavit filed in the meantime, Lordship, in the trial court, they have also agreed for settlement, Lordship. Lordship said that will appear there, and Lordship, or Lordship here, Lordship.
Whatever you tell me.
Lordship will be there, Lordship, and Lordship by file an affidavit.
All right. Counsel for the petitioner.
May I play one more thing, Lordship? By the order dated 6th of January 2022, Honorable Court observed that no one, there was no compromise. It was effected after January 2022. So let the already confirmed, already statement they have given in lower court, Lordship, that has been settled. That is their Lordship. They will because an earlier order was that as such no compromise was there in between the petition and the opposition party number 2. By the order dated 6th of January 2022, but thereafter the compromise was effected. Prior to that, they have filed affidavit. Now they are saying after that also they have filed affidavit. Payment was not made prior to 6th of January 2022.
Now have you received payment or not?
Yes, madam.
All right. There's an affidavit now of the informant dated 1st March 2019. No, but there has to be an affidavit after that, no?
After this order, Lordship, in trial court, they have settled and they have made a statement that matter has been amicably settled.
This CRLMC 658 says dismissed for non-prosecution. It was restored, is it after that?
Lordship, subsequent it has been restored, Lordship. Because it was dismissed due to default.
All right. Counsel, where is your recent affidavit? You got it in your hand, is it? It's not here on record.
No recent affidavit has been filed.
Oh, no affidavit has been filed?
No recent. They made statement there, matter has been amicably settled.
I see. If counsel for the opposite party number 2 states that the matter has in fact been settled between the parties, although a statement to the contrary was made before this court at the hearing on 6th January 2022. Paragraph. Counsel for the petitioner informs the court that opposite party number 2 informant has already filed an affidavit before the trial court that the matters have been settled. In that view of the matter, the present petition need not continue. It will be open to the parties to approach the trial court for appropriate orders.
Lordship, both the cases. Lordship.
The
Okay.
petitions are disposed of. All right.
Item 65,
The petitioner is dead.
Dead, is it? The petitioner has died. Petition is dismissed as having abated.
66,
I don't know 66 and 67. In both the cases, I am challenging an affair and the consequent proceedings. In the meantime, that is being already investigated and their final form has been filed saying that I kindly come to page 4. The affair is false.
So that's over there. A final form has been filed on 12th April 2019 stating that FIR number 24 of 2019 in PS Bamebari, District Kyonjar is false. That view of the matter, no further directions are called for in the present petition. This is disposed of.
And the consequent proceeding is
Basically, say if it is false, then what else remains?
a consequent proceeding is to be asked.
What were the consequent proceedings?
Well, they have initiated a proceeding on the basis of this affair. That is special case now 1 of 2019. So that should go.
No, if a charge sheet has been filed saying it's false, what further proceedings will be there? After the date of the charge sheet, was there any
immediately
proceeding?
after the affair, they initiated proceeding.
After this charge sheet, was anything done?
No, nothing.
Then that's okay. Unless there were any further orders after the charge sheet.
68. Item number 68.
Nana, please.
Yes, I am there.
Here.
Order of cognizance under challenge, my lord. You lordship, see, affair has come to annexure 1, page 8. Here, affair is on section 417 IPC. And on completion of investigation, IO submitted charge sheet by annexure 2, page 14. Under section 417 and 506 IPC. But here, what happened? The learned magistrate at page 19. Beyond charge sheet, he went ahead and take cognizance of the offense under section 376 IPC.
376?
Yes. It also should the FIR allegation, both the petitioner and
Now
victim.
charge sheet has been filed, correct?
Charge sheet filed since long, my lord.
Then?
Charge sheet annexed to page 14, which was filed in 2018.
So this is a separate thing then?
My lord? No, annexure 1 of the year at page annexure 1, page 8. FIR is there 2016, 1/11/2016.
All right.
FIR under section 417.
Right.
Then charge sheet filed under section annexure 2 at page 15, 417/506. Because both the victim as well as the petitioner, they both hail from same village, both are having good relationship. And the informant is also by the time occurrence to say the major lady, knowing fully well the consequence of that, the petitioner being not the married wife, preferred to stay together, keep physical relationship with her for years together. And on being refused for marriage, this affair has been lost. And here the magistrate what happened that beyond charge sheet, he went ahead and took cognizance of the offense under section 376 IPC.
There is the affidavit of the informant.
My lord?
Where is the affidavit of the informant?
No, there is no affidavit.
There is no compromise.
And there's no compromise.
No compromise.
Permitting the
376
petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated.
Item number 70.
The case, my lord. Same incident, my lord. One FIR was lodged and one complaint was filed, my lord. The FIR was ended with final report, my lord, as a case of accident. Without calling for report on 210, my lord, CRPC, the London Magistrate took cognizance of offense 302 against the petitioner, my lord.
Where is that order?
Let's you can see the annexure 3 series, page 21. Let's you can see page 20, my lord, the final report submitted by the police, my lord. Page 20, running page 20, my lord.
All right. You see,
Yes, ma'am.
the grievance of the present petitioner is that without noticing that in an earlier FIR, number 79, dated 27 July 2011. A charge sheet was filed. Arraigning the,
Final report is filed, closure report is.
a closure report was filed
This is that case, similar case your lordship has remanded.
in the. So you say 79 dated 27/7/2011. Under sections 279/304A against the present petitioner. A closure report was filed. No, it's not a closure report, sir.
Yes, madam. Final report was.
No, sir. It's a final report,
Yes,
not a
madam.
closure report.
Final report, the against discharge, my lord, against discharge. Final submitted, Vinakatan Naik is discharge, my lord. Let's kindly see from the above facts and discuss above is true case on 2734 IPC due to loss and negligent driving by the driver Vinakatan Naik under the.
The driver has died, is it?
Yes, ma'am.
The driver died.
Yes, ma'am.
Where do we get that?
Let's kindly see the page 20, my lord. For a last parameter.
No, that he died.
Final report was abated, my lord. It is a case of final report abated under section 2734 IPC.
Where were you named? Were you named in the, what were you, a cleaner, is it?
I'm not cleaner, my lord.
You're a cleaner.
No, my lord.
Ah,
I am the occupant, my lord. I'm an occupant.
occupant.
Yes.
Right. Earlier affair, a closure report was filed by the investigating agency on 3rd November 2011. Full stop. No protest petition was filed.
Complaint petition filed, madam.
No. Was any protest?
No protest.
Full stop. Thereafter, a complaint was filed in TR case in ICC. In 1CC case.
Yes, my lord. During investigation, complaint case was filed, my lord. Before final report, complaint case was filed. Because my lord, final report was submitted on my lord on 3/11/2011, but the complaint case was filed, my lord, but annexure 3, my lord, on my lord.
3/8/2012 only, sir. Later only. It was filed later, 3/8/2012.
No, my lord. Complaint was on 5/9/2011. FR was lodged on 27/7/2011. Complaint was 5/9/2011.
Where
Closure
is
report was
5/9?
5/9.
It's 10.
Page 10, lordship. Page 10, my lord.
All right. You see, it appears that before the closure report was filed, on 5/9/2011, a complaint petition was filed, which was registered as 1CC case number. (34/2011). Full stop. Already evidence has been taken in this 1CC case.
Should you kindly say, hey, my lord,
That
without
inquiry has been made.
without
Evidence of the witnesses have recorded by the magistrate.
should you kindly see, my lord, Annex 4, page 36, my lord, 35, my lord. The postmortem report, my lord, cause of death. That's you kindly see. Page 35, my lord. Running page 35. Nature of death, my lord. Untended accident due to fall over hardened rough surface. It is duty of master to call a report, my lord, 210, my lord, service, because it was.
There's no stay granted here.
Yes, my lord.
By now the trial must be over.
No, my lord.
How? 302 trial will not be over.
It is not on bail, my lord. That's reason.
Sorry?
Not on bail, my lord. That's the reason, my lord. Trial has not commenced.
Oh, petition is still absconding. On the record.
He's on bail.
Not,
No,
no, not
he's
in
not
court.
on bail.
Someone
So
was
he's
issued.
absconding.
Someone was issued. Someone is a complaint case.
Someone has.
Someone was issued.
So he's not appeared.
No.
So why should we entertain this then? It's a 302 case, sir.
Plus, kindly stand next to 4, my lord.
No.
Is it
You
postponed
take all
report?
these pleas. You first surrender and take all these pleas. He said permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. No way.
Item 71.
May I pardon?
Yes.
Item 68, may I prefer tomorrow? my lord?
What is that?
Permitting the petitioner to.
We permitted you to raise
No,
all
let
pleas.
it come tomorrow. There is recent decision of the apex court. Since the informant as well as the petitioner both are married,
Orders passed.
knowing,
Orders passed.
let it be tomorrow, my lord.
Sorry.
Recent decision of the apex court, I'll show it to your lordship.
Sorry, sir.
I pray for only tomorrow.
Sorry, sir.
Item 71.
Sorry, everything is sorry. I pray it for tomorrow only, my lord. Because there recent decision of the apex court.
71.
None appears dismissed. No.
Item 72.
May I please your lordship? My lord, item 72, my lord. Sorry, my lord.
Yes.
Item M, this matter already been settled in between the parties. The opposite party already filed affidavit before this honorable court, my lords.
Where is the affidavit, sir?
Affidavit already filed, my lord, before this honorable court.
You have a copy of the affidavit?
Even if some regarding settlement of the matter, some from the local police has come, my lord and brother, lord and friend.
Yes, my lord. Here in this case, I am appearing for the opposite party, my lord, and I have already.
He's appearing, I see.
Already filed, affidavit already filed.
Already I have filed my affidavit to that effect, my lord. It might be in record, my lord.
That is in file.
All right, let's see. This is criminal MC 779.
My lord, my lord.
All right. Yeah. You say there's an affidavit of opposite party number 2 stating that the parties have already settled their disputes. Counsel appearing for opposite party number 2 also confirms this. In that view of the matter, put down the prayer clause. And all proceedings counsel with that to hereby quashed.
Item 73.
Obliged, my lord.
Item 73.
None appears dismissed.
Both of them.
Yes.
Item 74.
None appears dismissed.
75.
75, my lord, here, and the counsel appearing for the opposite party number 2 has to file affidavit, my lord, because the matter has been compromised. The petitioner has filed an application for quashing of
an affidavit
on ground of compromise, and he has to file affidavit.
No, there is an affidavit.
My lord?
There is an affidavit.
Yes, my lord. The counsel
appearing, sorry, opposite party number 2 has filed an affidavit.
Yes, my lord. Counsel is not
stating that she has no objection to the quashing of the case against the petitioner.
He has not filed any affidavit. He's saying that
there is an affidavit, sir, 15/10/2019. There's an affidavit of opposite party number on record.
He has no idea.
There is an affidavit.
Okay.
So I pray on any.
Allow.
Yes, man, obliged.
That view of the matter, take from the prayer clause and all proceedings consequent that we have quashed.
Item number 76.
May please, Lordship, this is in my application. I've made a prayer for quashing of the proceeding, Your Lordship. This case relates to 2003 year, to the year 2003, Your Lordship. So therefore, I pray if Your Lordship disposes of with the direction that to expedite the matter.
All right. While the court is not inclined to interfere at this stage and permits the petitioner to raise all pleas at the appropriate stage in the trial court, the court permits the petitioner to request the trial court to expedite the proceedings. The petition is disposed of.
Obliged.
Item 77.
May I please, Your Lordship? I am filing a memo relating to the petitioner has died in the meantime, and a letter has been issued by the AIG Police Vigilance to the wife of the petitioner stating that final report awaited has been submitted on 8/9/2021. Madam. Petitioner died on 8/6/2021. Madam.
So it's over then. The petitioner is
But
dead.
till that it is pending before though this
That you point out there, sir.
your lordship may record that so that I can show it there.
It
And
stated that the petitioner has died. This petition is accordingly disposed of as having abated. The above fact may be brought to the notice of that concerned trial court. Right.
already I have filed it there.
All right. All right.
Item 78.
May I please your lordship? My lord, the two petitioners are, one is a assistant inspector of police and other is inspector of police, my lord. My lord, what has happened, my lord? One Jagdish Jena, assistant inspector of sub-inspector of police, my lord, on getting a reliable information that in the hotel of the opposite party number 1, some coals are being dumped. He went there and conducted a raid, and he found 3 tons of coal and arrested him and forwarded him to the court on 3rd of February. He was remanded to jail custody, and on 5th he was released on bail. That order I have annexed as annexure 2 and annexure the 3 and 4 series, my lord. And my lord, thereafter on 6th, my lord, on 6th of February, after being released on bail, he filed a complaint case making allegation that both the petitioner came to his hotel, ordered food, and which cost about 600 rupees. After taking food, they did not pay the bill and took away 20 liter of diesel and gave him fist blow, and they went away. And the London magistrate, on conducting an inquiry, has taken cognizance, and which is subject matter of challenge. My lord, in paragraph 7 of my petition, I have already mentioned that this opposite party number 1 has a lot of criminal antecedent, even including a case under NDPS Act, Bihar and Excise Act, under the Coal Gambling Act. There's cases I have mentioned. And while issuing notice, perhaps your lordship has directed the state council to get instruction regarding the antecedent of this. And this is a case on 5th. He was arrested. On 5th, he was released. 3rd, he was arrested. 5th, he was released on bail. 6th, he filed a complaint that making allegation that we have gone to his dhaba, took food and did not pay the money. There's a clear case of case on personal vengeance, which your lordship has already seen in the 1992 Supreme Court 604 in case of State versus Bhajan Lal, my lord. That is a clear case where the public officers are in trouble, my lord.
What do you say? You offer the complainant.
My lord, your lordship, kindly see the complaint.
That complaint allegation is there, my lord.
Apparent on the face of the complaint. My lord, the petitioners came to my dhaba and placed order, and I offered them food. Whenever I asked for money, they scolded me in filthy and obscene languages, assaulted me. Thereafter, I went to the police station, reported to the police. They did not entertain me. Left with no option, I filed a complaint case, my lord. And magistrate has taken cognizance of offence for so and so offence, my lord.
Right.
Thereafter, challenging that, they have come before your lordship.
All right. Permitting the petitioners to raise all fees the appropriate stage.
Lord, this is a case, my lord. Your lordship may kindly see. My lord,
Police implicated me. My lord, police has implicated me.
My lord, 2 days before.
Holding grudge on me.
Just a minute, my lord.
No.
2 days.
Just 1 minute, sir. I have passed an order not entertaining his plea. You want to continue arguing. So I don't know why you do this.
Sorry, man.
No, what I beg to submit, my lord. My lord, these people are public officers, my lord. Just I am the inspector in charge. I registered the PS case against him. I directed for investigation by the petitioner number 1. My lord, we IO and the inspector. The two had it been a long day, all it is understandable. My lord, just next day of his release, he started, my lord, doing this case.
Permitting the petitioner to raise all fees.
My lord, I will raise this point at the time of charge, my lord.
Whenever, sir. We're not saying which stage you should point it out. All right.
Item number 79.
My lord, what I beg to submit, my lord, that no coercive action till against.
Not necessary.
Because these are government officers, my lord. We are protected by your
enough
lordship.
protections, sir. You have enough protections. Yes.
79.
In this case, the complainant already died, my lord.
All right. You're what? You're the accused. Complainant died or the accused died?
My lord?
Complainant died or the accused died?
No, accused not died.
Who's the petitioner is what? The accused?
Petitioner, yes.
So what is the case?
Case for cognizance, quashing of cognizance.
Under what offense?
My lord, they have charged under section 294, 493, 376, 417, 306, 34. 376 is not attracted because the FIR laws, they have a love relation between both. According to
anyway, that obviously there's no affidavit now. If it's 376, you have to take all pleas at the appropriate stage.
I may be permitted to take all these grounds.
Yeah, permitting the petitioner to take all pleas at the appropriate stage. The petition is disposed. All right.
Item number 80.
Item number 80, no instructions.
No instructions.
Take all the charge at the time of charge, my lord.
Anytime, sir.
My lordship.
Item 29. Item 29.
Is it despite a pass one and appears dismissal or pass?
May I be pardoned to mention item 76, your lordship?
76.
Yes, lordship, in that matter, the petitioner is a old and ailing person, your lordship. If your
So he
lordship
permitted you to expedite.
expedite, obliged, deeply obliged.
Right.